And hello, everyone, and welcome to Uncivil Law, where, as always, we learn through the misfortunes of others. I am your host, Uncivil Law. We are back with the Alex Murdaugh trial, day 2 afternoon. So we have completed our initial round of jury selection. We had 4 panels come in between yesterday and today of about 80 people each, and we have done the initial voir dire to ask them if they are qualified. We now have a smaller group of people that will come in tomorrow morning for hopefully the completion of voir dire, where the attorneys will have an opportunity to ask questions and go into more detail. Today was just are you qualified legally under the law? Are you registered to vote? Do you live here? Are you a convicted felon? Stuff like that, right? Are you legally qualified? And today and tomorrow will be where the attorneys get to ask questions and get into more detail. For this afternoon, we're having a hearing regarding the admissibility or lack thereof of some evidence relating to spatter marks that may exist or not on the white shirt that Mr. Murdaugh was apparently wearing at the time that he at least discovered the bodies, if not committed the murders. We read some of the motions relating to this, and it seems to my mind that it depends a little bit on what the scope of the expertise is. I could see the judge narrowing or constraining the expertise in some way as a motion in limine. You could also see the judge exclude the witness completely, although that seems a little bit unlikely because a lot of this just seems like questions for cross-examination. The witnesses in this case, or the witness that they're moving to exclude, had one opinion that they couldn't find any blood spatter. And then they had some conversation with other law enforcement, and suddenly they can find 40 pieces of blood spatter. And we did a test that can't determine whether or not there's blood, but we did do a test that determines DNA. And we've determined that the DNA of the victims is on the shirt, or is it? Because there seemed like there was some inconsistencies in the motions. Like one seemed to say yes, there was blood, but not spatter, some other kind of blood. And then the other motions seemed to suggest no blood or no DNA. I was confused. But it seems to me that the most likely result of this, based on my very brief examination of the motions, is that the judge will either admit it and allow the jury to figure it out, or possibly give some sort of limitation instruction regarding some aspect of it, depending on the details. Again, I've been thinking about this for about an hour. So my opinion is not as well informed as the judge's opinion, who's been thinking about it longer and had more evidence to consider, and also had an opportunity to review the motions from the state, which I'm sure rebutted some of the defense's argument. But I could see problems in the defense's motion on its own terms. Like I could find problems, which, is not a great position to be in. So we are looking at having jury selection, the last of jury selection, start tomorrow, with the possibility of opening arguments tomorrow afternoon or maybe Thursday. It depends a lot on how long the jury selection process will go as to when that will end or not. And you had difficulties tweeting the stream out? So, but I appreciate you trying. I do appreciate you trying. And we're simply waiting for the stream to start. So I'll go ahead and just share the nothing as we're waiting for the stream to start with the afternoon argument. So this should be informative. It should be informative in a couple ways. It should be informative, as the preliminary hearings have generally been, as to the relative strength of the attorneys and possibly even the strength of their case, the quality of advocacy, and also the nature of the judge's considerations and what questions he does and does not ask, and his perceptions of what issues do or do not belong for the jury versus what he can deal with as a threshold matter. So it should be interesting all around. And I look forward to covering it with you just as soon as the court gets back to, doing stuff. And now we have a picture of a chandelier. The chandelier is a nice chandelier. It has 7 arms. And now we have a picture of a clock. The clock is somewhat basic. The clock is a wooden clock. It says 210. And now we have a picture of the state seal. we're doing different scenes from the courthouse now. We've seen a clock, we've seen a chandelier, and we've seen a seal. This is exciting. The seal looks crooked to you? It's a little hard to tell from the camera angle, but will there be a test later? Yes. How many arms were on the chandelier? What was the color of the chandelier? How was the chandelier being hung from the ceiling? Was it a nice chandelier? Would you want the chandelier in your home? Did the clock have a second hand? How many marks were on the face of the clock? Do you like the state seal? Do you like it? Because South Carolina has this dual state. They have a dual side seal, so they have to present you both sides of the seal. Do you like the seal? Is it a good seal? You're partial to walruses. What's the history of the seal? I'm sure you can find that on Wikipedia. I don't know off the top of my head. Oh, yes. And while we're listening, I guess I can also do editing work for the video based on this Crowder thing. So I might do some editing in the background. So I can post that when we're done with the stream. Let's see, broadcast recording from this morning, 24th in the morning. I'd like to download the video, please. And that's downloading. Great. What I have for lunch? Soup. I made soup. It's a beef and vegetable soup I made. It is both nutritious and delicious. Do I think tomorrow they'll do voir dire? Yeah. I have no reason to think they won't. Soup from scratch? Yeah, I made it myself. I used some beef chunks, and then I used these frozen vegetables made for soup that my grocer has. It's got like corn and green beans, peas, little potato in there. I did that. Did a why are we talking about North Carolina in chat now? Is there confusion? Anyways, so I did that and I put it into a crock pot for 12 hours along with some better than bouillon beef base and a little bit of better than bouillon herbal base and salt and pepper and a cup of wine and let it slow cook for 12 hours. I did mention the state seal, but why are we talking about North Carolina? Might as well. North Carolina is inferior Carolina. North Carolina isn't cool. You thought the case was North Carolina? You might want to take another look at that seal, my friend. If you thought that the case was North Carolina, you might want to take another look at the seal on that one. Yeah. Good times. Uh, is it still alive? As far as I know. Seal Watch is compelling. Moonshiners? That's cool, JoJo. You're smoking a 13-pound brisket? Sounds promising. And I think the camera's wonky is my working bet. Will the notification pop up on screen? I'm just waiting for the thing to pop up on screen, by the way. Still doing voir dire? No, not this afternoon. We're doing a motion hearing this afternoon. Voir dire continues tomorrow. Took a boozy break with Nate. I joined his chat for a second. Well, since the bot seems to not be reading it for some reason, I'll read it, and I'm sure it will read it as soon as I start. $4.99 from KJab. It's so cool to see you healing and grow. Thank you. I appreciate that. Be proud because it's hard work. What's the plan for Texas? YouTubing and or lawyering? Thanks. The plan is just YouTubing for now. The plan is just YouTubing for now. And I appreciate your super chat. Thank you. Did I turn off the thing? I did. Or at least it didn't turn back on. I was wondering why it didn't announce on screen. Okay. Something terrible happened, still have an aversion to me? I understand. Thank you, Jennifer. That's very kind of you. Appreciate that you like the style of videos I do. Try hard to make them accessible for you guys. Try hard to give you good commentary about things. I'm looking forward to covering this trial with you in all of its trial glory. There's the clock again. Did you remember how many marks were on the clock? Now you can inspect it more closely. There's the seal. Man, that's funny. I am now laughing at the changing between the seal and the clock. Feels like a discount store clock. Yeah, I tend to agree. Quick take on the clock. Let's look back at it and see if the clock has changed in any way. Maybe the clock has changed since we last looked at it. I mean, the seal hasn't changed very much since we last looked at it. But maybe the clock has changed. The clock is more dynamic than seal. Kurt makes me think lawyers are almost human. Can't have that, man. Chat must be on topic. Yeah, you guys can discuss the state seal of South Carolina. You guys can discuss the clock and you guys can discuss the seal of South Carolina. But none of that inferior North Carolina seal crap. Okay. There's the back half of the Crowder video edited, and now I just have to figure out where the video begins. Nothing could be fonder than to be in Carolina in the morning. Nothing could be sweeter than whatever the next line of the song is. Okay. Now I have a video. How long is this video? Let's see. It is 19 minutes long. Okay, so now I have a 19-minute video for this afternoon that I can release. So exciting. It won't be very good. It won't be very popular though, because I take what's being edited. I did a discussion about Steven Crowder Daily Wire during this morning stream, and I'm editing it out for a separate release. And so I'm just editing it out for a release, which is easy enough since I did it in one take. What's the chance of pleading guilty at this stage? I think incredibly unlikely. I don't think it's going to plead out. I doubt the state's going to offer anything attractive enough for him to settle out. Stephen acted like a child. I took a mixed, nuanced opinion, which is always really good for getting engagement and likes, as opposed to just being like, this guy's evil, this guy's in the right. Nuance doesn't really play very well on the YouTubes. But I took a mixed opinion. All right, so let's render that video. What time zone is in South Carolina? Eastern. You can't get much more eastern than South Carolina. I mean, to be fair, I mean, it is right on the coast. I know someone who went to family court for contempt. When they went, the judge said to list it out as counts and rescheduled. Does it seem like the judge would not want to touch it? I don't know. South Carolina is on the East Coast, north of Florida and Georgia. Maine is further east than South Carolina. Maine is also the closest state to Africa. We have a Cooking with Kurt live. Yeah, we've done it before. We've done Cooking with Kurt on the channel. We did cracked chicken one time, and we did some sort of chili, I think, one time on the stream. The cracked chicken turned out way too salty. We could give it another go. Texas over Virginia. I don't know about South Carolina. South Carolina, I grew up there. It's a state of which I'm proud. So I don't know about Texas versus South Carolina. That's a hard choice. I have fond memories of South Carolina. It's a beautiful state. Wonderful people. How far is South Carolina from me? Pretty far. I live in the middle of Texas. It's a hike for sure. Did I get rain? Not as far as I'm aware. Ever been to Canada? As a matter of fact, I've never been to Canada. I have been to Mexico, but I've never been to Canada. Florida? I could definitely see Florida in there. Florida's a cool state. That's a drive. Texas is big. Damn straight. Texas is a lot of drive. You can drive quite a long time and still remain in Texas. On my move from Texas, where would I go? I don't know. It just depends where opportunity leads, to be quite honest. If I find a woman and we get married and it's more practical for me to move to her than for her to me, then maybe I'll move to wherever she lives. Or maybe I'll find a career opportunity that looks really good or whatever. It's just, wherever opportunity leads. I missed the clock check. I did miss the clock check. This is disappointing. My heart's broken. I guess I could wind back and we could watch the check. All right, so I've rendered the video. Teach me to surf? That could be cool. Any luck on being a professor? Not so far. But I teach you guys, and that's fun. I have a daughter and she lives in Vancouver. You'll move here? Could be, Sarah. Could well be. Could well be. Although it's Canada. Canada's cold, and I don't really like cold. So we might have to negotiate on that. But, if it's love, I'll make do. Have I heard about the Snapchat video from Paul's phone 10 minutes before the time frame for the murders? No, I've not heard about that. Would geographical location influence the wife choice? Probably the other way around. The wife choice would influence geographical location. Are we compiling candidates? Yes. I'm still not married, so. Have I been to Cadillac Barbecue? No, I have not. I heard him mention it though. Isaac Baruch is here from Vice. Cool. Glad you're here. So far, we are staring at a state seal. Let's look up information about the state seal and talk about the state seal. Time for state seal talk. The Great Seal of the state of South Carolina was adopted in 1776. South Carolina seal is made up of two elliptical areas, linked by branches of a palmetto tree. The image on the left is dominated by a tall palmetto tree and an oak tree, fallen and broken. This scene represents the battle fought on June the 28th, 1776, between defenders of the unfinished fort of Sullivan Island and the British fleet. The standing palmetto represents the victorious defenders, and the fallen oak is the British fleet. Banded together on the palmetto with the motto, Quis separatat, who will separate us, are 12 spears that represent the other original 12 states of the Union. Beneath that is inscrolled on another of the alternate state mottos, Melorium lapsus lavat. Having fallen, she has set up a better one, with a date of 1776. Surrounding the image at the top is South Carolina, and below is Animus Opprespi Pariti, prepared in mind and resources. The other image on the seal depicts the Roman goddess Spes, who is the god of hope. The other image on the seal depicts the Roman goddess Spes, walking along the shore that is littered with weapons. The goddess grasps a branch of laurel as the sun rises behind her. Below the image is her name, Spes, Latin for hope. And over the image is the motto, Dum Spiro Spiro, meaning while I breathe, I hope. The full coat of arms of the state, adopted soon after the seal, consists of arms above, along with personification of liberty, holding a Phrygian cap and laurel wreath on the left, as well as a continental soldier on the right as supporters. Above the shield, a personification of fame goes from liberty to the soldier. The Great Seal of South Carolina was set or fixed by ordinance of succession of December the 20th, 1860 at Succession Hall in Charleston, shortly after 7 p.m., following which the convention delegates signed it, including Robert Barnwell Rhett. As some 3,000 South Carolinians watched enthusiastically the proclamation of South Carolina as a separate individual nationality.
They can only create one list, and that's the strike sheet. Is that correct, Clerk, Madam Clerk? So you know that you have 123 qualified jurors.
123?
One juror called in and indicated that her mother is taken to the hospital and will have surgery tomorrow. What juror number is that?
It's right here on your bench, sir. 343.
Juror number 343. That her mom's having surgery tomorrow. She found out today, and she cannot serve. So I've excused juror number 343. So we have 122 jurors. When the jurors report tomorrow, there'll be a strike sheet.
122 from which we need to get 18. I think we'll be fine. Hopefully.
Or less, or more. Any questions by the parties?
None from the state, Your Honor. None from Mr. Murdaugh, Your Honor.
All right. We'll proceed now to motions.
Your Honor, I've been in conversation with the defense over the lunch break as we discussed some of the motions that have been filed and that are pending. I think many of them are motions that are appropriate to arise during the course of the trial as witnesses who address them come up. I will point out that there are a number of motions that the defense has filed as it relates to a particular blood spatter expert, that being Tom Bevel. In conversations with the defense, we have agreed at this time that that will not be discussed in opening or before the jury. And of course, we will alert the court when that testimony is approaching and have an appropriate in-camera hearing at that time. So I think that's addressing that particular issue as of today.
Yes, Your Honor, that's correct. And we'd also filed a motion regarding Mr. Kinsey having similar spatter expert opinions, and we had requested a counsel hearing as part of our motion, and what we had agreed to is once we get to that part of the case, if they decide to call Mr. Bevel, then we'd have to have a hearing on Mr. Bevel, and then we'd also, whenever they call Mr. Kinsey, if they intend to offer spatter opinion testimony, we need a counsel hearing for that.
Sanctions motion.
And the sanctions motion is still pending. We're not withdrawing anything, but I think once they make a final decision as to whether to use Mr. Bevel, and he's here, then we can address all those issues.
Is that right, Mr. Waters?
Yes, sir, that's correct.
All right, fine.
Your Honor, there's a couple of states motions just to mention real quick, and I think that the same issue should be in play because these are really more trial issues. There was a motion in limine to exclude evidence related to third-party guilt. As Your Honor is aware, there are longstanding law in South Carolina that precludes the defendant from going into conjectural inferences of third-party guilt unless they meet the standard, which of course means that evidence must be limited to such facts as are inconsistent with the defendant's own guilt and to such facts as to raise a reasonable inference or presumption as to his own innocence. Obviously, that's the kind of evidence that I think has to meet that standard before it's admitted, but it's also the kind of thing that we don't know what it's going to be until we hear it. But we did want to raise that issue with the court, but again, I think that's something that will be addressed as it arises during the trial.
Your Honor, we agree with the state's analysis of what the law is. We not sure what witnesses are going to call. There's a couple, 2 or 3 of them on there that we may have to confront this issue on. But that and the polygraph, we obviously understand polygraphs are not admissible except under very limited circumstances. Those are issues that would arise should they call witnesses that took and failed polygraphs, as we've said in our motion, like Eddie Smith.
Thank you for the gift
and
memberships, by the way.
would only arise in a limited context. But there's no reason to pure conjecture today as to whether they'll call any of those witnesses and whether those issues arise. So we obviously would not blurt out polygraph. We would ask for ask the jury to be excused and deal with those issues, or third-party guilt, deal with those issues at the appropriate time during the trial.
And that's, of course, the point, Your Honor, and that's acceptable, just like the spatter expert, because stuff like that can be highly prejudicial to a jury. It's just to make sure that before we get into issues of third-party guilt or issues of polygraph, that the defense advises the court and we have the opportunity to address those issues outside of the presence of the jury, get guidance from the court before we proceed.
Oh, my goodness, Judge, I would never consider reporting it out, ever.
All right, very good.
Your Honor, I know we had previously, back on December 7th, we had some extensive argument about the state's motion and the defense motion for a bill of particulars, the state's motion to admit evidence of motive. Today, we received a motion from the defense specifically addressing one aspect of the boat case, seeking to limit testimony about the boat case, and in particular, a particular discovery motion that was pending on June 10th of 2021, just days after Paul and Maggie were murdered, and seeking to sort of limit testimony as to that. Your Honor, we obviously have made some extensive argument on that particular issue, and I don't know if the court has any guidance or any ruling just generally on the admissibility of the motive based on the arguments that have been made, and certainly I'm happy to make any further arguments in that regard. We have that issue, I think, that's still outstanding, and then the other issue is that the defense yesterday filed a motion for a counsel hearing on the admissibility and of the ballistics evidence, tool mark and firearms identification evidence. And that is something that we think needs to be addressed. We're prepared to have an evidentiary presentation on that, but we believe that needs to be addressed before and ruled upon, Your Honor, respectfully, before the jury is sworn, as that is a significant piece of evidence, and as much as the cases found around the body of Maggie Murdaugh match, or at least match pursuant to the analysis of the firearms examiner, weathered cases that were found at other places on the Moselle property, and we believe substantial evidence shows that that they are from a .300 Blackout AR-style rifle that was purchased by Alex Murdaugh and can no longer be accounted for. And so that's obviously a very crucial piece of evidence, and I think we need to have a ruling on that particular issue prior to the jury being sworn because of its significance.
Yes, Your Honor. I'll take the financial crimes evidence motion first. We have fully briefed that. We did argue it. I think we were in Florence, and subsequent to that, we filed our written response with case law and an attachment. They filed a reply. Happy to argue further if you want to hear argument on that. With regard to the ballistic motion, Your Honor,
They lost the rifle?
we did file a motion in limine and requested a counsel hearing on the. We have gotten a report from Mr. Greer, the SLED ballistics expert, and essentially he says that
Now for
based
the
on the
prior thing
markings
now.
of shell casings found at the crime scene, 300 blackout shell casings, and specific markings he relies upon are tool marks from extracting and ejecting the shell casings, the cartridges that have been fired. We're not talking about the bullet, but we're talking about the cartridges, spent shell cartridges, that the markings on those found at the crime scene match markings of fired shell cartridges at a shooting range on the property and around the residence. And he puts those two together, says they match, and therefore they were fired from the same gun. What we've asked for a council hearing is what's the basis for his opinion that they had to be fired from the same gun? What studies have been done to establish that like fingerprints, which is their theory, that only one 300 blackout made in the world would produce those markings
That seems
in
like
the era of mass production of extractors, ejectors, and so, you know, we were asking what's the basis of his opinion for that. We cited studies that are critical, but you know, we don't know of any 300 blackout studies that have ever been done, and so, you know, that is the basis of our motion. We think it can be taken up when Mr. Greer testifies. But
This is the motion that you filed today?
yesterday, Your Honor.
Yesterday?
Yes, sir.
Now, obviously, it's a very significant motion. I filed a response as quick as I could early this morning, and in which we cited extensive case law. As Your Honor is aware, there was the NAS study in 2007, 2008, and then sorry, Your Honor, it's in, and I know because this is so late from the late filing of the defense, I'm sure you probably haven't had the opportunity to review these.
We've got a
But there
video
was
for this
study
afternoon
in late
now.
2008, 2009. That called into question firearms and tool mark examination. I've done one of these hearings before, and then there was a subsequent 2016 study as well, PCAS study. So there's the NAS study and the PCAS study. If you look in our brief, Your Honor, though, the Attorney General of the United States of America refutes the report, the FBI refutes the report, the Association of Firearms and Tool Mark Examiners refute the report, and the overwhelming weight of the case law that's cited in our brief that we filed this morning, including very, very recent case law from federal courts, from North Carolina courts, from Kentucky courts, of course, have affirmed the long-standing admissibility of firearms and tool mark identification and examination in the courts. And we actually quoted extensively, just to show you how long this has been accepted evidence in the South Carolina courts, the State v. Hackett going back as early as 1949. So this is obviously a well-established field, and obviously they have the opportunity to cross-examine any expert and to raise any
Both
issues
sides
that they
attorneys
want,
are really
or to
sharp.
put up their own expert.
I really like the way
but
both
as
attorneys are.
always,
They're doing a great
particularly
job.
with such
They're
a
well-spoken.
well-established, well-used, in almost every
good arguments.
firearms
They're very
type of
competent.
case, type of evidence that's been accepted in the South Carolina courts for decades and decades and decades. Any issues that they may want to raise
Can't hear
go
me?
to weight, not admissibility. That's the general rule there.
I agree, Mr.
Turn it down some more. Can you hear me now? Check 1, 2. Can you hear me?
Conclusion is that no other
Turn my mic up.
weapon could have possibly fired those rounds.
Check 1, 2. How are we doing
That's
now?
not exactly how it's phrased, Your Honor. Just one second.
Anyways, I made my video for this afternoon, so that's posted for 6 o'clock. So that's exciting and fun. And I was commenting that both attorneys' sides are really good. I was commenting that they're really both very good, very competent, very lucid,
Just,
making strong
clarifying with
arguments.
counsel there. And
They're
just
nice.
to be clear, Your Honor, there were spent cases found around the body.
Better? I'll turn myself up more. How about that?
There were spent cases.
Is that better?
Found next to a stoop on the side of the house right outside the gun room where Paul Murdaugh and his friends like to cite in 300 blackouts, one of which is now missing.
All right, great. We're all happy.
By the family. There were also spent cases found on a shooting range on the property as well. What the firearm examiner will say is that his conclusion is that all those cases bear markings similar with one another, that they were all cycled through the same weapon. So I don't want to overstate the
Too loud?
conclusion.
Turn it down.
That's the nature of the conclusion that he will offer, is that the individual characteristics, the subclass characteristics,
Hopefully that'll work
of
for
that
people.
particular of those examinations show that those cases were cycled through the same weapon. And again, he can get on the stand and put a finer point on it, but they're of course very aware of the standards that which they can that they need to apply, and of course very aware of the limits to which they can go.
Is he here today to testify?
He is, Your Honor.
All right. Is that the council hearing that you all wish to have?
The state's position is it needs to take place before the jury's sworn, because obviously this is a very significant piece of evidence, and we need guidance from the court as to your rulings before we proceed. So we are prepared to have that hearing, yes, Your Honor, on short notice.
And for the defense?
Yes, John, we're ready to go forward if Mr. Greer's here to address it. And the issue, frankly, is what's in the case law that we've cited is the level of certainty that you can say as to it came from only one versus, there are similarities. I mean, that's the case law talks about just how certain the opinion is permitted and what's the basis for that.
All right, let's call him to the stand and have a hearing.
May I address one other matter not related to the weapons? We did file a motion this morning after, and I understand its weight, but so was the discovery they gave us on Friday. I mean, this has been sort of a late game playing both sides. We're not playing games, we didn't wait. But there's a motion pending, was filed yesterday, to preclude testimony on a question of law. And obviously, we're not asking them to respond to that today since it was filed yesterday, but certainly something we could do tomorrow morning, or depending on your ruling on the motive evidence. I mean, simply put, what they're arguing is that there was going to be a hearing on Friday in which he was going to have to produce financial information, which when he got questioned that day by the
What the hell's happening right now?
the financial person at the office about the $750,000, that panicked him, that he knew the jig was going to be up on Friday. Well, two things. One, nobody can say what was in his mind. Number two, and as we outline in this memo, Your Honor's tried enough civil cases, and I have too. All you're entitled to on punitive damages is a net worth statement. I mean, God knows as a plaintiff's lawyer, I've asked for much more than that. Never had a judge give me anything more than a net worth statement after a prima facie case of punitive damages was shown. Now, Judge Hall, who would have heard this motion had it gone forward, did hear a motion against the co-defendant, Parker's, where Mr. Tinsley asked for the same thing, and he denied the motion and said, when we get to trial, if you show a prima facie case of punitive damages, then you get it. So the most he could have gotten on Friday was a net worth statement, which wouldn't even come in. Well, first of all, Parker's didn't even have to produce that until trial. What did he do? What did Mr. Murdaugh do in his vocation as a lawyer? He's a plaintiff's lawyer. He and I have talked about this. We never got anything other than net worth statement after there was a prima facie case in front of a jury. So what this motion deals with is excluding sort of opinions of what the law was, or what would be, what would happen in front of the judge, some prediction.
There's some sort of problem with this court at the moment.
Nobody certainly knows what he thought. We have witnesses, I believe, that may testify that he was asked to prepare a net worth statement, which, as you know, again, one of my
I have
complaints
essential
as a plaintiff's
tremors,
lawyer,
Ellen. I have
really
essential
doesn't give you a
tremors.
lot other than what their net worth
And the
is,
ass
because
sometimes.
that's all the jury can hear on ability to pay, net worth. So if you want to, we think you should allow them perhaps to respond to this in the morning and take that into consideration on your decision on motive evidence. And we'd be happy to argue it in full. I've done a pretty poor job of doing it here right now.
Just in response, Your Honor, they did just file this motion, but it's never been the state's contention that somebody's going to testify and predict what Judge Hall would have done in this particular case. What we can, and there is testimony, and already in state grand jury transcripts, which they've had access to for months and months and months and months, is testimony about the manner in which the plaintiffs in the boat case were conducting that litigation, what they were expecting, what they had received from the defense, the fact that the defense had claimed that Mr. Murdaugh was broke. They didn't believe it, and so that's what ultimately led to the motion to compel. The motion to compel did not ask for a financial statement. It very clearly asked for identification of bank accounts and other sort of financial information with the intent to subpoena that. That was the motion that was on the table for the very week, just a few days after Maggie and Paul were murdered, on top of the fact that Mr. Murdaugh was confronted the very morning of the murder by his own law firm seeking missing fees. That's the temporal connection of those two events that then tie back to literally a decade of embezzlement that one question begets another, which begets another. To understand why these are significant, the jury has to understand that he had been stealing for over a decade, 99 counts to date, and facing essentially life without parole on these particular financial accounts, and that's the significance of what he was trying to prevent from being exposed. So again, I hear what their motion is, but I think this motion will be moot and ultimately will be resolved during the course of testimony because no one's trying to say what Judge Hall would do. The point is a little different. It's what the plaintiffs were seeking to do and what they had very clearly said to Alex Murdaugh and his attorneys during the course of that litigation.
To get information, they were going to file, and litigated with Mr. Tinsley, very aggressive. He filed a bunch of motions to get financial information, bank accounts he could not have gotten, because you're not entitled to argue about financial ability to pay until you get a prima facie case of punitive damages, and that's what we say here. So he could file whatever he wanted, but to say whether Mr. Murdaugh thought that was a real threat or not, what he thought, and I will tell you that it's not consistent with the state of the law, not consistent with my experience, and I understand, Attorney General has not litigated a lot of civil cases. I have, since 1986, been trying to get more than just net worth statements in a punitive damages case. Never have gotten it. The last point I make is this. His theory, and this is sort of, is that he knew the jig was up, so he went home and blew the head off his son, and butchered his wife. There's not one shred of evidence there was any problems between any of them. There's texts, pictures, people that were with him the previous weekend at a ball game, video from that day with Paul and he having a good time. There is no dispute anywhere that they were the perfect family in terms of their relationships. No divorce, no separated, no left him, no nothing. So this is a fabrication, and they want to use what Mr. Griffin described as bad character evidence. He stole all this money, so he must have killed his wife and son. That is, and as he cited, there are at least 6 South Carolina Supreme Court cases.
Bad character versus motive.
How many? 4.
Let's be cautious.
4 South Carolina Supreme Court cases disallowing, and judges were reversed, disallowing this kind of evidence. Now, if they've got some evidence that Maggie was getting ready to turn them over to the feds, or Paul knew about it and was getting ready to talk about it, or he'd been threatened by them, certainly those cases say that's when that kind of stuff can come in. But not this theoretical, we ain't got a motive, we're going to make one up motive. That isn't.
What I'm getting from you, both of you now, are you give me jury arguments, and you're arguing multiple motions simultaneously. Regarding the motion by the state,
simplify.
for me to
One thing at a time.
grant an in limine motion admitting evidence. That's what you're seeking me to do. And you in your motion, you indicate that the basis for this is for judicial economy, that there may be no precedent for the court ruling in advance of any testimony granting in limine the admission of motive as evidence during the trial. You seeking to have me do that?
Well, Your Honor, I recognize what the court's saying. I think the first issue with that was in response to the defense bill of particulars, and our response to that was they essentially asked. They said, "Tell me what financial evidence you want to go into." And so we responded by saying, "Well, that's not recognized under South Carolina law, but we filed this particular motion."
I
Yes, sir.
understand all that, but typically a motion in limine is a motion to exclude evidence.
That's correct.
Your motion in limine is for me to admit evidence. And what authority do you have for me to admit evidence through a motion in limine?
Well, and of course, in our motion, and stand by for me, Your Honor, just 1 second.
Yeah, I've never heard of such a concept. Admitting evidence in a motion to eliminate, that's not what a motion to eliminate is. Motion to eliminate, as the name implies, is a motion to limit. You're asking the court for a
motion is to exclude evidence, but the cases that we cite and the language we cite in our motion, of course, is to prevent disclosure of potentially prejudicial.
You're asking
matter
the court to
jury,
take official notice.
and of course is
You're asking the court to
strictly
adopt
conditional
a fact
and
that's
subject
true.
to the actual evidence
That's
being
a wholly different
offered.
thing.
And so the point was to, because it's very extensive and because we realize that this case is different. As I've argued, this case
that
is much
different.
different than any case we've ever seen because of the complexity of all these factors going together.
It's not
I
that
think
different.
Essentially, what we were trying to do is at least get
It's a murder
get
case.
some sort of preliminary guidance, understanding that evidence will have to be developed at trial as to the admissibility of this. Now, ultimately, if the court is more comfortable with having in-camera proceedings as to the admissibility of evidence, then I understand that, and we can do that as the case develops, as we were talking about the other things.
Well, this will create a mini trial, given all of the various offenses, 90-something allegations. And of course, we also deal with the issue of res gestae, issues of matters that may be too remote in time, and the like. What I'm grappling with is your request for me to grant the in limine the admission of evidence.
Yeah, that doesn't make any sense.
I frown upon motions in limine, period, because I don't know the facts. I do not know the facts in this case. I know what you all.
The judge is telling you straight up
submitted
how
in
he
your
thinks. He
briefs,
frowns
your-
on motions in
your
limine.
arguments, and
Okay.
whatever you say is the case.
He doesn't like
the
'em.
defense says the opposite.
It's like,
That's why
well,
we
this
have
is what I like as a
testimony,
judge.
and
This is
judges
my
are to
style.
rule
So,
not
you're
based on
stuck with
lawyers'
me.
arguments, but based on evidence. And I am not prepared to grant in limine
Yeah.
a motion admitting evidence.
Yeah, the judge is
Though
like,
it may be
the judge is
admissible
like, no.
under the same theories that you have promoted.
Now, are you going to take the L, or are you going to be a dick
agree with
and argue
the
until you win or something, or you get shut down?
authority and the rule that
You just
allows
lost,
for
deal.
motive to be admitted in a case under appropriate circumstances. And your all's argument in the cases cited by the defense, some are remotely similar in facts, and most of them are dissimilar. Each case must
Your
be
precedent
decided
is
on
garbage,
facts and
says the judge.
I believe that
Your precedent is garbage as applies to this
Secret
fact
case is
pattern.
Persuasive authority,
Law.
US v. Secret.
Your precedent sucks.
Though in that case,
I'll translate for you.
very noted jurist.
You're asking me to admit something in a motion to
time
exclude.
in our
Your precedent
state,
sucks.
Was reversed.
I don't like
by
doing
one
this.
of our noted jurist, Judge Traxler, on the same issue. But I'm not prepared to grant admitting evidence in limine. It must be done during the course presentation of the evidence.
Maybe try presenting it. Maybe try presenting the
Understand that, Your Honor,
evidence.
and again, I
at trial. We'll
recognize
see what
that we were
happens.
attempting to perhaps identify those issues and bring those issues because of the complexity of everything to the court's attention, and I certainly understand and recognize, and that's the typical manner in which we would do that, is to have those issues addressed as we move through the trial.
That deals with that issue.
You may lose your evidence, says the judge. I'm not ruling on this. I'm not telling you the answer. You may lose your evidence. Lol.
Your Honor, I believe at this time we can
Next
move
issue.
to that. I'm going to turn the presentation
How about
of
no?
evidence over to Mr. Fernandez.
Judge said, how about
who
no?
will, call
Okay,
Mr.
no, it's a
Greer.
correct answer. Great.
Thank you, Your Honor. May it please the court. State will call Paul Greer.
Okay, so now we're doing this thing. We're doing this expert thing on what they will and will not testify to. So this is a motion in limine. So we're having this expert testify to determine what they'll be able to testify about. Fine. I also liked where the judge was just like, you're arguing all these things at once. You're arguing all these motions at once. It'd be like, shut up. One thing at a time. What's the issue? You want me to admit evidence through a motion in limine? How about no? Okay, what's the next issue? Fire.
My name is Paul Greer, Greer.
With whom you're currently employed?
I'm employed at the South Carolina Law Enforcement Division, which is commonly known as SLED.
All right,
What a
Mr.
great
Greer, for
accent he
purposes
has.
of this, counsel,
He has a
would you
great
please
Southern
just,
accent.
Describe for the court your educational background and qualifications in the area of firearms identification.
Yes, sir. I received a Bachelor's of Science in Biological Sciences from the University of South Carolina.
South
At
Carolina.
the completion of my collegiate career, I began an internship at SLED in the Fireman Toolmark Department. I was appointed as a firearms examiner, a forensic scientist in the laboratory in 2014, where I began the SLED Fireman Toolmark course of instruction. This is an extensive training program that's conducted under the supervision of other court-qualified examiners. During that time and extensive period, I conducted many written and practical examinations, conducted many microscopic
Oh yeah, I believe this
comparisons,
guy's a
and
gamecock
assisted
through and
other
through.
examiners prep their
I have no doubt in
cases.
my mind.
At the conclusion of my training, I was then given a comprehensive final exam that included mock casework and was able to begin casework on my own after successfully completing.
There is a farm program. There's a farm program at
you.
Clemson too.
And Mr. Greer, would you please describe for us the field of, broad overview is fine for purposes of today's hearing, but an overview of what firearms identification is and the expertise that you've developed.
Yes, sir. Firearms identification is a discipline of forensic science in which our main objective is to examine fired ammunition components in order to determine
This is a
if they were
preliminary
fired by a
hearing.
specific firearm.
This is a preliminary hearing. We're having the witness testify to determine what the witness will be able to testify about. That's what we're doing now.
Are you a member of any organizations, or have you obtained any additional trainings or certifications as it relates to firearms identification?
Yes, sir. I am a member of the Association of Fireman Toolmark Examiners, which is also known as AFTI. I've been a member of that organization since approximately 2015. AFTI is an international organization that I believe has approximately 1,200 members of folks in the field who do firearms identification and toolmark identification. This also includes technical leaders from the academic world and also from other aspects.
Thank you. And if you would, please describe the process that you go through and the training that you go through in order to become a forensic firearms and tool examiner at SLED.
Sure. That refers back to that course of
So
instruction.
what I understand
that
is they don't have the
included,
rifle.
That approximately 3-year or so program.
They don't have the
where I
rifle.
conducted all the microscopic
And they
comparisons,
apparently
looked at,
want
things on
this
the
guy to
microscope,
testify
test-fired firearms,
the rifle they don't
observed
have.
Cartridge cases that were fired
The
out
bullet
of the
that
same
went through
firearm,
the rifle they don't
cartridge
have
cases that were
matches
fired
that
out of
rifle.
different firearms,
And so
bullets
it must
as
have been
well.
that rifle that did
Learning
the
about
murders.
firearms,
That's where I
manufacturing
understand where
process of
we're
those
at.
Firearms and how that relates to.
So the bullet that went through the
range of
rifle we don't
conclusions
have
we
that was
issued
owned
as
by
firearms
Alex Murdaugh,
examiners.
it must have been that
During that
rifle.
time, I also completed
the
those,
rifle we don't
written and
have.
practical tests. Some of those tests include
Okay, good luck.
studies that have been conducted throughout the United States and worldwide to include consecutively manufactured bullets and cartridge cases. I've completed those, successfully passed those. At the end of my training, I was given that final exam, and also some mock casework in which I was able to complete and successfully pass.
Thank you. And have you had a chance, I know you mentioned you're part of the AFTE organization, AFTE. Have you had an opportunity to attend additional conferences and trainings that they would put on on an annual basis?
Yes, sir, I have. When I'm able or training is available, I attend their
Bullet went through the same
annual
rifle as another
conference.
rifle was fired on the property? Yeah, that
is
might work.
A large conference where
If you can determine it was
materials
fired by that
presented,
particular rifle.
About new
That might work.
technologies in the field or updates, new procedures that may be
Maybe.
coming in order to do things or arrive with different items. But I attend those conferences when able. I also participate in other training as necessary.
It's going to match the extractor
our
ejector
Glock
markings
armor
on brass.
certification when that
I've never studied it formally,
when
but
I'm able to
I
do
would
that.
be I would
AFTE
be
also
amazed
has
if you
other
can get
things
a
they provide.
unique match from
Webinars, if I'm
extractor
able to
markings.
participate in those, I will take
There's
part
enough
in.
detail to get a unique match.
And in order to become
I've never
a
looked into it. That
firearm
seems
and tool
unlikely, but
examiner with
okay.
SLED, are you given certifications and tests that must be passed, both competency tests and proficiency tests?
Yes, sir. Part of our quality control at SLED, SLED, the laboratory is accredited by ANAB, which is the ANSI National Accreditation Board. That follows the standards set forth by ISO 17025, which is an international accrediting set of standards.
There are two firearms used in this
And we
in
follow
this
that,
crime,
and
a
within
shotgun
that,
and a
we
rifle.
have a SLED quality control manual that requires before we're able to participate or be authorized.
I'm not sure why they
to
don't have the rifle. I
we
don't know.
are competency tested and deemed competent to do that. Also, in addition, each year we are proficiency tested to make sure that we are maintaining our competency.
Okay. Mr. Greer, specifically relating to the purpose for which you were called today, in describing the area of firearms identification, would you please tell the court a little bit about the methodology that goes into that, and whether that methodology has been subjected to both being, published in journals or subjected to peer review? Would you please talk about that whole process and the culture?
Sure. Firearms identification has been around for years. During that time, there's been many studies that have proven the reliability of firearms identification. Those studies are published in articles through AFTE, such as the
With
AFTE
respect
Journal.
to the
Those
rifling,
studies,
I
using
believe.
a scientific method are
With respect to the extractor
published
markings,
in the AFTE
I'm
Journal,
dubious.
Or Journal of Forensic Sciences would be another one that could be included. And those are peer-reviewed. Those are looked at by members of the academia or firearms identification, other examiners. Those are reviewed and those are published in those two journals for sure.
Do you know what year AFTE was founded, for how long this organization has been around?
I believe AFTE was founded in 1969.
All right. And discussing the methodology of peer review, you indicated that the journals, that the information that's published in journals, that's in fact subject to peer review, meaning other people in the field or folks in the scientific community are able to review it and analyze it. Is that your understanding of it?
Yes, sir. That's my understanding. They would be able to review the article as it's presented prior to publication, review what has taken place in that article or that experiment, and share their thoughts with that process. Those articles are then, peer-reviewed and issued in those journals.
These articles are not only information, but it's also sometimes and frequently an examination of some study that was performed. Is that your understanding of these articles and review of those articles?
That's correct.
In addition to the methodology and peer review publications in your field, could you please discuss the specifics of that peer review process and methodologies in SLED in particular? Sure.
As part of our quality control process at SLED, again, we are accredited by ANAB. We just received our reaccreditation. We're accredited every 4 years during that cycle, and we just received our reaccreditation. And that, again, follows the ISO 17025 standards. We also, on top of that, have the SLED quality manual, which we follow closely to make sure that we're adhering to those procedures. And as part of that, we have a firearms departmental manual that gives us guidance in how to perform our actual casework, how to perform our examinations with the evidence. In that process, in that quality control peer review, our
I don't know who
casework
Blondie
at
is.
SLED is 100%
sure.
micro-verified. And that means that another qualified examiner will look at the evidence, arrive at their conclusions, and agree or disagree with me. For those to be reported, that examiner, we will, if he or she agrees with my results, those will then be reported. The case file itself also undergoes a technical and administrative review process as part of the quality control and peer review procedures.
And as part of your in-house peer review, is that a blind review that is performed?
Yes, sir, that is.
And speaking of the organization, sort of the accreditation organization, ANAB, is that an international organization?
The ANAB stand is in the United States, but they follow the international standards set forth by ISO.
Thank you. And then the second layer would be, so SLED itself, the organization, the law enforcement agency SLED is accredited by ANAB.
The Forensic Services Laboratory is.
And then beyond that, SLED Forensics has a quality assurance manual which is followed by your lab. Is that correct?
That's correct.
And then beyond that, the SLED's firearm department has its own manual. Is that correct?
That is also correct.
All right. Has the field of firearms identification been applied in previous similar situations?
Yes, sir.
Okay. Well, let's start with sort of the big picture, the broad picture. Where and how is it typically applied? This field of study.
That sheriff looks like the most disinterested
Firearms
sheriff I've ever seen in my
identification
life.
has been around for years.
That
Since
sheriff in the
early
pews.
1900s, we have,
It's like this. Could we get someone,
been
the sheriff, that
evolving
like
on firearms identification.
has any more excitement in them whatsoever?
And it's used in court cases across the world. Is that
The
correct?
sheriff may
sir,
may
that's
fall
correct.
asleep.
Specifically relating to your personal experience, have you been sworn as an expert in firearms identification in previous court cases?
Yes, sir, I have.
And providing live testimony for a trial?
Yes, sir.
And approximately how many cases was that?
I've testified in state and federal courts approximately 25 times.
Certified or firearms identification examiners have been utilized in, as far as you're aware, per your organizations, have been utilized in court cases across the globe. Is that your understanding?
Yes, sir.
I know you mentioned that this field of study has been around since the early 1900s. Does this applied science use the scientific method when applying, your information you gather and then your opinion that you render?
Yes, sir. It does follow a scientific method and approach in order to conduct our examinations.
All right. Could you please describe what the scientific method is as applied to this forensic field?
Sure. As far as applying a scientific approach, when we conduct our examinations or we're looking at firearms in the scientific method, one thing when we're working a case or if you're looking at it in this manner, you may ask, you form a hypothesis, are these cartridge cases fired by this firearm? So that would be our hypothesis. We would evaluate the conditions under that, do research, and then we would actually do experiment. In this case, in this example, what we would do is test fire that firearm using similar ammunition that we're comparing it to. We would determine our conclusions and arrive at those conclusions. Then that can be also applied to casework. If I receive a case, I look at all the evidence, look at the characteristics on that, examine the firearm, test fire that firearm. I've already compared those cartridge cases to each other and determined that the characteristics of that firearm can be compared to those cartridge cases, compare that, determine a conclusion. In order to determine, and then our peer review process kicks in order to determine whether that is reproducible or the repeatability of that scientific procedure. That's where our peer review process would come in. Another qualified examiner would come in and look at that. And if he arrives at the same conclusion, then that method has been deemed repeatable and reliable.
Thank you. In the 25 times that you've testified in both state and federal court, has your testimony been ruled admissible, meaning you could render your opinion to the jury?
Yes, sir, it has.
And were any limitations placed on your testimony in the 25 times you've appeared?
There were none.
Okay.
All right. The field of this forensic field of firearms identification, could you please describe the quality control? I know you have mentioned some, but could you please describe the quality control procedures that are in place governing this body of work?
At SLED, again, we are accredited under the ANAB policy, which guides us under those standards in our quality control manual. I'm sorry, could you repeat the question?
What quality control procedures are in place, both in this field of study in general, but also as it relates specifically to how SLED operates? I think you meant, first of all, what's the international accreditation that SLED is, the forensic lab is a part of?
Yes, sir. That is the ISO 17025. So accredited laboratories around the United States, if they are accredited by ANAB, they are all working with those same standards that we are at SLED. They're all adhering to those quality control procedures. Additionally, those who are accredited under the ISO 17025 internationally are also accredited by those same standards and follow those same quality control procedures.
And in order to obtain that accreditation and, more importantly, maintain that accreditation, how much, what's the inspection process, both internal and external? Describe
Yes,
this.
sir. For the ANAB accreditation, we have an on-site visit every 4 years where auditors come and examine our casework, examine our facilities in order to make sure that we are complying with the requirements set forth by their governing body. They review everything that we offer as far as casework, make sure that we're complying with our own policies and as well as theirs. As far as internally, we also complete internal audits each year where other departments will audit and make sure that there's compliance within each department.
And although redundant, please describe to us the SLED quality control manual that's followed in the laboratory.
Yes, sir.
Can you describe it? What essentially is it, and how do you follow it?
Yes, sir. The SLED quality control manual follows those standards that are given by ANAB. It follows that so that way the SLED laboratory has strict guidelines in which
I understand all the general
to make sure
principles.
that we
I get
stay
it.
in line with our accreditation procedures and policies.
Can we get down to the specifics of
And if you would, again, although
what
I know
exactly
you
you
explained it
compare it to
previously, but
what
please describe
and
the firearms
how you're able to
department manual
determine
that's followed.
a match to what level of
The
confidence?
firearms manual is a set of procedures
That'd be
that we
helpful.
follow as examiners.
You're
in
an
order
expert
to,
in the field. I got it.
Give us instruction and information.
You
on how
follow
to complete our
procedures that are
examinations, how
set
to
by
handle
national and
firearms-related
international
evidence and
organizations.
tool-mart-related
Cool.
evidence. It also
Great.
includes
Got it.
some terminology that we use within
Moving
our case
on.
files. It gives us guidance to make sure that we are all operating consistently and within those guidelines of the quality control procedures.
And if you would also please describe the code of ethics that is applied to yourself and your colleagues within the laboratory.
Yes, sir. Each employee at the SLED laboratory, including myself, signs a code of ethics that we must abide by each year, and that is a code of ethics for the workplace in our forensic laboratory, and that is recorded within our quality control procedures.
An additional quality control procedure would be the micro-verification process. Please briefly describe that for us again.
Yes, sir. Before a conclusion is rendered via report, each examiner will examine the evidence, arrive at a conclusion, write those conclusions down. At that point, another court-qualified examiner will examine the evidence and arrive separately at their conclusions to create a blind verification. If those conclusions
Me, he's fine
are
as an expert.
the
I just
same,
want to get
then
to an issue I actually care
reviewing
about.
examiner will sign off on those conclusions.
You're an expert. You
so
follow
that a
international
report can be
standards. You follow
drafted.
national standards.
It's also part of that process.
It's
The
a
entire
established
case file and
science. I got
report
it.
are,
Okay,
reviewed
great.
For a technical review
Let's
and
move to the
administrative review before
what you
the
did in this
report is
case
released.
start. You know,
And in order to become forensic examiner with SLED, is that person required to pass a competency test?
Yes, sir, that is correct.
And you in fact passed that competency test?
Yes, sir.
And are there also proficiency tests that are required each year?
Yes, sir. We do take a proficiency test within our discipline each year.
All right. Please, we're going to talk a little bit about, but I'd like you to describe how the area of firearms identification is consistent with recognized scientific laws and scientific
I don't
procedures.
care.
So I think you mentioned before, but
I'm ready to move on to
is,
the next
firearms
thing.
identification, do you all operate under the general
Just laying foundation.
rubric
I
of
know.
the
I know. I'm
scientific
just ready to move on to other things.
Yes, sir.
And again, describe the scientific method and how it relates, maybe how it applies to the firearms identification, beginning with
I'm
essentially
impatient.
a hypothesis,
I'm ready to
or
move on to other
a
things.
hypothesis, and then proceeding along to where it becomes a theory. Could you please describe that process?
Yes, sir. You would look at your evidence, or in this case, if you're just doing an experiment, and try and determine a hypothesis. Are these cartridge cases fired by this gun, or are these bullets fired by this gun? You would do the research to determine what materials you may need. In this case, you may use like ammunition that you're trying to compare to. You would examine those characteristics to make sure that the comparison should be completed. At that point, you would begin your experiment. In this case, you would test fire the firearm. You would compare those.
Do you have the firearm? I was under the impression that you didn't have the firearm.
And also with
Was I mistaken? Do you have the firearm?
Cartridge cases or bullets that are questioned, and arrive at conclusions. At that
So if you have
point,
the firearm, that would be real helpful.
conclude your experiment, issue your conclusions, and open up for any discussion. That is similar to casework in the fact that's a very similar method as what we use there. For repeatability and reproducibility of that, at that point, that experiment could be passed off to others in the field of firearms identification or in academia to review and comment. They could use the evidence or the cartridge cases and conduct their own experiment with it and see if they arrived at those same conclusions. If they do, then that theory has been proven and considered reproducible and reliable.
And generally speaking, in the applied sciences, is it important that the test be as accurate as possible? The test you're trying to reproduce in the lab.
Yes, sir.
Is it important that it's reliable, meaning you can rely on the procedures that you're implementing and the results you're trying to obtain?
Yes, sir.
And is it important that it's repeatable, meaning you could repeat that same process, or your peer review colleague could repeat the same process? That's an important component of this examination.
Yes, sir. That would be an important component of the scientific process.
In addition to all the scientific method and the processes you just described, again, this field of study, this applied science, is it also published in journals and academia for peer review?
Yes, sir, it is.
And are you familiar with some of the literature out there, having reviewed it yourself?
Yes, sir.
Is this how the trial's going to go? Absolutely, 100% yes. For sure. Okay, we have the foundation. I've got it. You're an expert in the field. There are journals. There are accrediting organizations. We follow the standards. We follow the accrediting organizations. I got it. I understand the basics. Can we move on to whatever we did in this case, please?
All right, Mr. Greer, thank you for answering my questions. I do have a couple other areas I'd like to ask you about, specifically relating to some of the criticisms that was referenced in counsel's motion, specifically 2 National Academy Sciences reports and the what's been referred to as the PCAST report. Are you familiar with those 3 areas?
Yes, sir, I am.
Okay, great. I'd like to ask you, let's just go in chronological order if that works for you. Beginning with the first National Academy of Sciences report in 2008. I believe it was, well, tell me are you familiar with that study?
Yes, sir, I am.
Do you recall generally what the study related to, the title or the area, field that they explored?
The 2008 article from the NAS was an article by a group of researchers dealing with ballistic imaging.
If you would, and you have familiarized yourself with that report, is that correct?
I am familiar with it.
What are some of the point, before we go into the reports, having established the foundation for his expertise, we do request that Mr. Greer be admitted as an expert for purposes of the rest of this testimony in the field of firearms examination.
Before the defense proceeds with, you have some questions for him? You have voir dire for this witness?
Not on his qualifications, Your Honor. For purposes of this hearing, that he is certified, I believe, under AFTE. That I don't have any questions on his qualifications.
All right. He's so qualified.
Shifting back then, Mr. Greer, to the first NAS, National Academy of Sciences report. The test was conducted on ballistic imaging technology, and was it critical towards that field? The general gist of it?
Yes, sir. Your Honor, may I refer to my notes?
Yes,
Uh-huh.
Take about a 2-minute break.
Okay, like I get the basics. I understand that that this is a developed field. There's science and stuff, and you follow methods and procedures. I get it, but like, what exactly did you compare against what? My understanding is you don't have the rifle. So if your procedure is we test fire the rifle, well, you have a problem. So, and he said it like 3 times. So, first of all, do you have the gun? Second of all, either way, like, what did you do? What are you comparing against what? Exactly. How are you doing that? And is there enough reliability in it? You know? Can you get enough unique marks from even a fired casing to get a unique match? I mean, I guess you can say consistent or inconsistent, but as they point out, like most rifles are mass produced, and I'm slightly dubious on how much you can include or exclude a firearm based on the casing. And we're back to the shield. Maybe I'll learn something. Maybe I'll learn something about how good. Because, like, I understand that, you know, when a bullet is fired down the tube, you know, you've got the lands and grooves. And obviously, as you fire more and more, those are going to wear down in unique ways. And I understand that, you know, after a while that you might be able to get a unique pattern that would be somewhat akin to a fingerprint. I'm just a little bit skeptical in my own mind that that's possible with the extractor. Even with the firing pin, I'm a little dubious. Maybe it is possible. I don't know. We'll find out things. Here's the chandelier again. It's a beautiful chandelier, and we're back to the clock. I want chandelier. I want the chandelier back. I was enjoying the chandelier, damn it. Bring back chandelier. Bring back chandelier. Bring back chandelier. Bring back chandelier. All right, now we're stuck. Now we're stuck with clock. To the 600 of you who are currently here, thank you very much. For those of you who have not done so already, if you'd be so kind as to please retweet the stream. The stream link for Twitter is pinned as a pinned comment. I do create a new tweet for every stream. So even if you tweeted a previous time, you have to tweet again. Or I'd at least appreciate it if you did. So if you'd be so kind as to retweet it and help bring some attention to the channel, it'd be great. The clock says moo. No, that's not right. The clock says ba. Bah. No, I don't think that's right either. I'm now amusing myself. The clock says nay. uh, What the clock is broken, then we're all screwed. They have shotgun shells from the crime scene and from his property. Well, be that as it may, that he didn't test fire it. And I mean, again, I wouldn't know, but I'd be surprised if you could get enough unique markings on from a firing pin or an extractor to uniquely identify a firearm. But I'm not an expert in the field, so what do I know? Only 1 p.m. tweet for today. That's where it should be. That's where it should link to. You just coming in and see Kurt's lost his mind a little bit. Yeah. I mean, I could see the markings being enough to be like consistent with or inconsistent with, because I understand that the parts will wear. I just wouldn't think that the wear would be enough that you'd be able to say that, that this came from this firearm with any sort of real probability. But what do I know? There are no grooves in the shotgun barrel? Not typically, no. Not typically, no. And even if there were, the grooves wouldn't leave any marks. So, yeah. The extractor could have a unique tell. I suppose it's possible in some circumstances. Okay, I buy that. I buy that in some circumstances it might be possible. I just wouldn't think it would be true as a general proposition. Yeah. So, like, if it had some sort of really weird thing that would be abnormal, and it had something that would be abnormal and would be atypical, then I can understand that. I just wouldn't think it would be true in general. I think the markings and cartridges are enough to narrow it down the type of firearms, but the rifling itself that works more as an identifier. Yeah, that's kind of my understanding too. It's like, yeah, the rifling I can see where it would leave enough of a mark.
Hey, you may proceed.
The extractor and firing pin, I'm less convinced.
Mr. Greer, I believe we were referring to the 2008.
It stamps his
National
signature on
Academy's
every
report.
spent casing.
Yes, sir.
What is this? Judge Dredd?
All right, could you please outline some of the criticisms that were raised by that report?
That report brought into question some of the reproducibility of firearm-related tool marks and whether the additional research of the reproducibility of those firearm and tool marks should be done.
Yeah.
And as it stated, what was the primary focus, or what area was that focus of this 2008 report?
The primary focus of that research, or the reproducibility of the the tool marks from firearms, was conducted through the ballistic imaging software. It did not take into the account of the human, such as I, an examiner working on a microscope, looking at that with my eyes. It was all in the ballistic imaging software.
We're going to get into some of the opinions you might have on the report, but in general, is it fair to say that the that the report focused on the technological component of things and declined to take into account perhaps a full picture?
Yes, sir. I believe it failed to take into the account of the human in the process, looking at it with their physical, with their eyes on a physical microscope.
And read in vacuum, if one were to simply read the 2008 report without any context or understanding of the firearms identification field in general, do you agree that it was a fair or accurate reflection of your field?
I feel that it could have included more of the human interaction with the examination process, more in line with what I am accustomed to doing at the SLED laboratory.
Do you feel that it was a
Hey, there is a new
accurate
sheriff here.
reflection of what examiners
Either that or
do
the
and
sheriff had a
skills
massive
that they
change in a
obtain
very short
and
period of
utilize?
time.
An examiner goes through a rigorous training process, extensive research during their training, looking at many microscopic comparisons, and whether or not they're issuing articles throughout their career to be peer reviewed in those journals, they are doing research during that training process, comparing known items to each other and known non-matches, looking at the difference in those, and I feel that this article, if it didn't take into that account of that human interaction, looking at that, the ballistic imaging technology may not have accounted for that.
And just in how many do you know, or roughly how many exams or examinations or analyses have you performed in the field of firearms identification?
At this point in my career, I would say thousands of comparisons.
All right, and concerning still on this 2008 report, was there some, did the issues of the report have to amend or issue corrections on the report in certain instances?
The 2008 report was not intended to cause any issues with the admissibility of the firearm and tool mark evidence
It wasn't intended to?
There was a statement from the Dr.
Did
John
you write it?
who was a member of the study, who had to address some of that information, and that the NAS report did not mean to cause that situation to occur.
Huh?
All right, thank you, Mr. Greer. Shifting focus to the second NAS, we're calling it the NAS report, that was performed in 2009. Are you familiar with that report?
Yes, sir, I am.
And have you had an opportunity to review it prior to today?
Ben Shapiro did his first
I am
rumble.
familiar with the report.
All right, describe to us, if you
All right,
would,
you're right
what the nature or the substance of that report was focused on, the area that it was focused on.
The report was generated, and it made 13 recommendations regarding forensic science. 6 of those recommendations related directly towards fireman tool marker AFTI, and those are the recommendations that I'm more familiar with.
Okay. So, and just to be clear, while the report issued 13 total recommendations, 6 would apply to your applied science field of firearms identification.
Yes, sir. 6 of those directly relate to that.
It's not just
All
the
right, if you
extractor
would,
or firing
let's
on,
walk through,
but the casing
of
will
those
expand
6,
within
let's
the
walk
chamber
through what
and
the
leave unique
recommendation
chamber
was,
marks.
and then I'd like you to address your analysis of that and what your agency does, as a response to that. So, beginning with the first recommendation, was there a recommendation to establish standard terminology?
Yes, sir, there was.
Okay, and in general, that's what the NAS report kind of touched on. What is, how does SLED operate with all the certifications we've understood? How does SLED operate as far as terminology?
Yes, sir. At SLED, we as firearms examiners utilize the AFTI glossary, which is a book of terms related to firearm and tool mark identification. That glossary is used by examiners all over the world, as AFTI, again, is an international organization. And that glossary has been available since, I believe, 1980. So it's constantly been updated as needed, new terms included. But we've always had that glossary, and to refer to. In addition, at SLED we have certain procedures that we follow to use certain terminology or abbreviations that standardize our reporting or case file documentation.
What would be the second recommendation that the 2009 report issued that would relate to your field?
The second recommendation dealt with establishing quantifiable measures due to the reliability and accuracy of the forensic analysis.
Okay. And if you would, just explain generally what that means, what the recommendation was.
Basically, what they recommended was that the reliability and accuracy of the forensic techniques should reflect the practice on case scenarios. They should establish the limits of reliability and accuracy and using those analytical methods that can be expected to achieve when looking at, to achieve as the conditions of forensic evidence vary. There's been many articles published throughout the history of firearm and tool mark identification that address the reliability and accuracy of our field. Ever since it really became popular in the early 1900s, they used that scientific approach, and since then they've built upon that hundreds of articles discussing firearm and tool mark identification, comparing those fire cartridge cases, those bullets, those ammunition components, and determining the reliability. There's studies that address that and using different scenarios, and also help to provide some insight as to the reliability of it.
And to SLED, the two situations you've mentioned, the scientific method and that approach, as well as the studies, articles, and peer review, are those two areas that SLED has already incorporated into its field of study?
Yes, sir. Part of our peer review is part of our process in order to complete a case at SLED.
All right. If you would, please describe the third recommendation from the 2009 report.
The third recommendation was basically to, in summary, what they wanted was to establish protocols for forensics examinations, methods, and practices.
All right. And how does SLED already address those recommendations?
Yes, sir. Again, we have those protocols set in place in our firearms manual, in which we are able to follow to guide us through our examinations. We also fall under those accrediting bodies of ANAB and ISO 17025 that guide us in accordance with those international standards. And that's how we've met that standard, and we've been fulfilling that.
And for purpose of just brevity and economy, all the protocols and standards we've established previously, that would apply to this recommendation. Is that fair to say?
Yes, sir. In my opinion.
What would be the fourth recommendation from the 2009 report?
One of the highlights from the fourth recommendation was laboratory accreditation. And individual certification of forensic science professionals should be mandatory, and all forensic science professionals should have access to the certification. Certification requirements should include examination, supervised practice, proficiency testing, continuing education, and adherence to a code of ethics, as well as other things. But that's a quick summary of that recommendation.
All right. And would you please explain how SLED operates within that recommendation?
Again, the accreditation process, as we were just reaccredited. Also, after going through the extensive training program, we are competency tested. We're giving those extensive practicals and terminology tests and essay questions to complete. We're given those competency tests to include the casework that represents an array of the type of cases that we'll be working on. We have to complete those and successfully pass that.
Maybe it's just me, but I still
proficiency
don't really
tested
have any
each year.
understanding
Each
of how any of this
examiner
relates
is
to the
proficiency
case at
tested
hand.
in order to
It all feels
maintain
general,
and prove
which
that
I
you
suppose is
maintain
fine
your
for
competency.
foundation.
And
I'm just waiting
we
for,
attend
like,
continuing education as we are able to.
how this
by
applies to the case
participating
at
in
hand.
webinars, attending the annual conference of AFTI, and so on. And also, the Code of Ethics, we sign that each year.
Here's some criticisms that have been made of the field.
Laboratory.
But
All right, please describe, if you would, Mr. Greer, the fifth recommendation from that report.
Yes, sir. The fifth recommendation was forensic laboratories should establish a routine quality assurance and quality control procedures to ensure the accuracy of forensic analysis in the work of forensic practitioners.
And describe how SLED already operates under that suggestion recommendation.
Yes, sir. Again, the accreditation with ANAB, ISO 1705, adhering to that SLED quality manual, the peer review process that our casework undergoes to make sure that it's all reviewed 100% before issuing those conclusions and those reports.
And finally, the sixth recommendation from that report. Would you please describe what it is and how SLED already operates under it?
Yes, sir. That was the Code of Ethics. The National Institute of Forensic Science, with its advisory board, should establish a national code of ethics for forensic science disciplines. And we have the Code of Ethics that we sign to guide us through for forensics in the workplace.
All right, thank you, Mr. Greer. The final study that was referenced in council's motion is called the PCAST, P-C-A-S-T report, which was done in about 2015, 2016. Are you familiar with that report?
Yes, sir.
All right. Could you please tell us a little bit about that report, kind of overview of what essentially it was and what some of the findings were?
Yes, sir. The PCAST report was a report that was issued by the President's Council of Advisors on Science and Technology. They issued the report entitled Forensic Science in Criminal Courts, Ensuring Scientific Validity of Feature Comparison Methods. Basically, this report, and I apologize, challenged us as firearms examiners in a few different methods with some of the things that they recommended for firearms or found issue with in the field of firearm and tool mark identification. I apologize. One of the issues that they noted was that firearms analysis falls short of the criteria for foundational validity because there's only a single appropriately designed study to measure the reliability of firearm and tool mark analysis. The other was that they had issue with those studies and how they were designed. Another issue was brought forth to firearm and tool mark examiner were the methods in which we arrive at our conclusions. That is to include the subjective and objective measures that we take to arrive at those conclusions.
Have there been criticisms of the PCAST report?
Yes, sir. There have been some criticism of that report.
Have you reviewed some of the criticisms of that report?
I have.
Do you share do you agree with the criticisms that you've reviewed?
I am familiar with some of those criticisms, and I do, as an examiner, agree with the responses by some of our scientific groups in firearm and tool mark examination.
Could you share some of the criticisms that called the validity of that report into question since its publication?
Yes, sir. Part of the one of the things with the PCAST report is the group of researchers who compiled that report. None of those researchers had any firearms identification experience. I believe, in referencing some articles, that none of those had even worked in a forensics laboratory. and only 2 had claimed that have any backgrounds in forensics. So none of those people who compiled that and issued those statements about fireman tool mark identification even claimed to have ever been in a forensics laboratory. So that is one issue. As what we do is very specific, and we undergo lots of years of training to arrive at becoming a competent examiner.
Has AFTI, the organization you're a member of, have they rendered criticisms and responses to the PCAST report?
Yes, sir, they have.
Okay. And are you also familiar with the organization OSAC?
Yes, sir, I am familiar with that.
What is that organization?
The OSAC is the organization, of scientific area committees. That is part of a committee that each forensics discipline has a group in, and that is a committee that's within NIST, which is a federal scientific organization.
You mentioned the committee NIST, that's NIST,
Yes, sir.
and that's the National Institute of Standards and Technology.
Yes, sir, I believe so.
And is your understanding that that's a federal organization as well?
Yes, sir.
So OSAC is under the umbrella of the NIST organization?
Yes, sir, that's correct.
Beg the court's indulgence. That's all the questions I have, Your Honor. Certainly happy to hand over to defense counsel. Mr. Greer, thank you.
Mr. Griffin?
Good afternoon, Mr. Greer. Good afternoon. Or Agent Greer, I apologize. You mentioned that you had been qualified to testify as an expert in some 25 cases, courtrooms like this?
Yes, sir, I have.
And in this case, isn't it true that there is no weapon that you were able to test to see whether these, well, let me strike that. You were able to test a weapon of a .300 blackout type to see if that weapon, shell casings and other, I guess the bullet, if you will, projectile matched what was found at the crime scene. Is that right?
Yes, sir, I did receive fire cartridge cases and projectiles to compare to a rifle.
And you used the methodology of the AFTE to perform the test. Is that fair?
Yes, sir, and also our SLED firearm department manual, which is a document that I would follow to conduct those examinations.
And I believe that in that .300 blackout that you used was found in the gun room at the House of Moselle. Were you aware of that?
I am not sure the location. I'll have to check the submission paperwork to the laboratory.
In any event, you were provided a firearm, item 33, I think, in your report, and you test fired it and compared it with what you provided that indicated it came from the scene. Is that right?
Yes, sir. May I refer to my report?
Oh, sure, absolutely.
Your Honor.
Your Honor, what was marked one court's exhibit for Your Honor?
I gave it to him, so no objection.
And it is attached to our motion. So, Agent Greer, I believe you have identified item 33 in your report as one Palmetto State Armory model PA-15 semi-automatic
Palmetto State Armory.
blackout caliber.
Nice.
Is that correct?
Yes, sir.
Represent.
And in your report, it said that this rifle was test fired using the item 34 magazine, and during the test firing, the first available cartridge in the magazine was fed and chambered correctly, and that then you test fired and extracted and ejected from the rifle. How were you able to, I guess, exclude or maybe your result was inconclusive that item 33 did not fire did not extract and eject the spent cartridges found at the scene? And your analysis is item 128 of your report.
As far as the cartridge cases from the scene, which items are you referring to?
Well, the ones that were seized from the scene are items 2 through 7.
Okay. Yes, sir. The results of the comparisons of items 2 through 7 in my report, when I compared those with each other in test cartridge cases that I fired from that item 33 rifle, the results of those comparisons were inconclusive. That means I am unable to determine whether those items were fired by item 33 or by another firearm with similar characteristics.
And then you also, as my understanding, you matched up spent shell casings, items 2 through 7, with other spent shell cartridges or casings, specifically items 35 through 37, 39, 108, 113, 116, and 17, and 122. And then you concluded, what did you conclude with regard to that analysis?
Yes, sir. I concluded that matching individual identifying characteristics were found in the mechanism marks of items 2 through 7, 35 through 37, 39, 108, 113, 116 through 117, and 122 to conclude that those items had been loaded into, extracted, and ejected from the same firearm at some previous time.
Now, is it clear that you did not have the firearm, that your opinion is
You were able to
was used
determine
to
that
extract
from
and
the markings
eject those
to a
cartridges?
sufficient degree of confidence?
I am able to determine that those cartridge cases had matching mechanism marks listed there, but in comparisons with the item 33 rifle, I'm unable to determine if they have been fired by that rifle or not.
Okay, but let me ask you, what's your opinion with regard to the spent shell cartridges, items 2 through 7, with the other spent shell cartridges you identified?
Which cartridge cases are you referring to?
35 through 37, 39, 108, 113, 116, and 17, and 122.
It's my opinion that those all had matching mechanism marks. Another
Define
common term
matching.
here for that is cycling. So that means that those cartridge
What do we mean
cases
by
at
matching?
some point had been cycled through the same firearm at one point in time. I was using the marks made from those. The
How
extractor,
unique
the
is
ejector,
matching?
and other chamber marks, the lug marks to make that identification. So those cartridge cases, I'm able to say have been cycled through the same firearm at some point in time, but as results of comparisons with
The same firearm,
with the,
really?
Item 33 rifle with items 2 through 7, those at the scene, the results of those comparisons were inconclusive as having been fired by.
So I'm a little confused. You were saying that let me ask you, how can you get ejector and extractor marks from one firearm at a previous time? I mean, can you do it without firing the bullet? Is that what you're saying?
Yes, sir. The cycling marks sometimes could occur just from cycling through the firearm. For instance, if you were to load a cartridge into a magazine, or cartridges into a magazine, load that magazine into a firearm, and chamber that unfired cartridge into the chamber of the gun so it's in battery, ready to fire. If you decide not to fire that weapon, you may, in this case, it was a rifle, pull back on that bolt handle. In that case, in that instance, the unfired cartridge would be extracted from the chamber of that gun and ejected. There can be marks left on an unfired cartridge due to that process without having firing the
That are unique enough to get it down to the firearm?
So what level of certainty do you have as to the fact that, in your opinion, that items 2 through 7 were loaded into, extracted, and ejected from the same firearm at some previous time as items 35 through 37, 39, 108, 113, 116 through 17, and 122? What's your level of certainty?
That is my conclusion.
That doesn't answer the question.
After I examined the evidence, I arrived at that conclusion based on the years of extensive training, looking at thousands of comparisons, and basing that conclusion upon that. If I thought it could have been a different answer, it could have been inconclusive, but I was able to determine that the agreement that I saw on those items was sufficient enough to determine that they had been cycled through the same firearm at some previous time.
Do you hold that?
I
opinion
doubt
with a
that's
reasonable
possible.
degree of scientific certainty?
It's my opinion that those had matching mechanism marks.
Once again, define matching. What do we mean by
They
matching?
have matching mechanism marks, but are you able to state with a reasonable degree of scientific certainty that only one weapon in the entire universe would have produced those matching marks?
Based on all of the markings and tool marks and cartridge case and fire bullets that I've looked at in my career, I have examined and conducted thousands of comparisons. I've participated in studies and competencies in which I look at things to determine if they were fired by a particular firearm, and able to build a foundation in which I can base my opinion. And it's my opinion that based on that training, based on those studies I participated in, some of those included consecutively rifle barrels, consecutively manufactured slides, and I've successfully passed those, that based on the information there, after I examined those cartridge cases for those markings, it's my opinion that those items all shared matching mechanism marks and have been loaded into extracted.
That doesn't answer the question
from
either.
the same firearm at some previous time.
Are you aware of any studies that
You're
have ever
telling
been
me-
done on a 300 blackout?
You're
300
telling me that
Blackout
two
is
firearms,
a newer caliber,
mass-produced,
I'm not aware. at
one
this
serial
point in
number
time.
after
I'm
the other.
Sure, there may have been research
After
but
the other,
I do
after
not
the
have,
other.
research with me today.
you're telling
on
me that you
cartridge
can
cases of that
eject
caliber.
a
Are you
casing
familiar with how the 300 blackout is
from
manufactured?
from 5 firearms that were all made by the
With
same
basic,
factory in the same line, same
manufacturing
mass-produced, and you're
processes.
telling me you
Yes,
can
sir,
tell me
that's
which of
right.
the 5 it came from?
So,
Bullshit.
And in fact, some company
Bullshit.
or gunsmith will assemble a 300 blackout from component parts using the various component parts that are mass-produced. Is that correct?
Are we talking about component parts of the rifle?
Yes, sir.
Different manufacturers choose to make their parts, or they can have those supplied by other vendors. Yes, sir, I suppose so.
Do you know how the 300, do you know how any of the 300 blackouts that Mr. Murdaugh purchased for his son Paul were manufactured, where they were purchased, how they were assembled?
I do not have information as to how they were purchased or assembled.
Okay. Are you familiar with production lots? How, say, rifle barrels are produced in a production lot, mass production?
Yeah.
Yes, sir.
Okay, and are you familiar with any studies that have concluded that projectiles fired through rifle barrels produced in the same production lot have identical markings?
I am familiar with certain studies. Some of those I participated in as part of my training that are known around the United States and internationally. that consisted of those consecutively rifled barrels. That means that they were made by a tool
Rifle
at the same
barrels.
approximate time in the same state of wear.
Rifle barrels,
I've also
I have a
done
little bit
those
more
studies
confident
with,
in
cartridge cases
than
looking at
the
consecutively
extractor.
manufactured breech faces. And we as fire
If you're
protection
telling
examiners
me
are
that
aware
you
of
can
those
tell me
markings.
which bullet
And in those
came out of
studies,
which gun
they're conducted
from
because
rifle
in the fireman's
markings,
tool mark identification
I'm more
mark,
inclined to believe
if
that.
you're expected
If
to
you're
see
telling me
those
you can
carryover
determine
of
which
those
casing
markings,
came out
we
of
would
which
expect
gun
to see
from
that,
the
on
extractor
tools that are
markings,
made- or excuse me, on
I
barrels that are
am
fired
doubtful, sir.
consecutively, or those breech faces that are manufactured consecutively, because that's when that tool is passing over that surface one after another. And I've conducted those studies, such as the Beringa 10 barrel test, the Hamby breech face test, the Glock Ebus barrels, which all have consecutively manufactured items within them. And I was
Once
able to
again, I
distinguish
would think
between,
barrels
those items, and looking at them under the microscope,
are not
evaluating
quite the same
those characteristics
as the
that are
extractor.
exhibited on those fired components, and correctly identify and associate those with the correct information.
And there we're talking about I guess, what do you call the inside of the barrel of a pistol or rifle, correct?
Yes, sir, that would be the bore of the barrel.
The bore of the barrel.
Right.
Are you familiar with any studies with regard to what you relied upon here, which would be extractor and ejector marks?
That's
Yes, sir. There are studies that have shown the reproducibility of those markings, and how firearms examiners were able to distinguish between those manufactured components.
And are you familiar with
Within
any
the same
studies
lot.
of the component parts that were used in 300 blackouts?
within the same lot.
Sorry, can you repeat the question?
There's
Are
enough
you
to
familiar with
distinguish
any
on the
studies
extractor
that were
marking.
done on the extractor and ejector component parts that are used in a 300 blackout assembly?
I don't have any information with me today in regards
You guys
to
can tweet it,
300
Ian.
blackout.
You guys
But
tweet it,
all
Ian. Tell him
those
he's needed.
Components are machined in similar ways.
Tweet it, Ian Runkle.
They
Tell him his
all
services are
have
required
similar
under
manufacturing
civil law.
processes. And I've demonstrated throughout my training that I was able to distinguish between those consecutively manufactured parts. So just because it may be in a 300 blackout, if I may have done that in something similar, such as in those tests with the Ruger pistol or the Glock pistol, and was able to distinguish, even though they may share similar manufacturing techniques. I don't have an article with me here today in regards to specific to that caliber, but based on my knowledge of the manufacturing
I'll
process
send
and
Runkle a
environmental
text.
mark identification, I would expect to be able to rely on that information as being reliable to examine that caliber.
Now, as I understand it, you examined the, I guess, spent cartridges and under microscope, and you compared items 2 through 7 with the others to conclude they matched. Is that correct?
I was able to say that items 2 through 7 had the matching mechanism marks.
Now, what matching mechanism marks are you referring to?
Those would be marks that are from the ejector or extractor. That could include the chamber marks or lug marks that we see on that type caliber ammunition.
And are those the
All right.
only marks?
I've sent
that
Ian a text
you saw
message.
that
Let's see if he wants to come on.
Based on my examination, those are the
When Runkle
marks
gets
that
sleep
I
right
was
now?
able
I
to
don't know.
conclude
Maybe.
that matched. When I looked at the totality of that cartridge, that fired cartridge case, to look at the firing pin or breech face marks, I was unable to determine that if it was fired by the item 33 rifle or by another rifle that was similar.
I understand.
What?
The mechanisms that you say matched,
So
how many
let me get this straight.
points?
You can determine that
Did
the
you conclude
ejected
match
case
in
that's
order to
not
reach
fired
opinion that
is unique, but you can't
was
determine that the
vacuum?
fired casing is unique. Okay, that makes
Sorry, I
sense.
don't understand the question.
When you compare tool marks, how many specific markings on an item do you need to find that match in order to say that it's a match?
Yes, sir. At SLED, we use a process of pattern matching. So in that pattern matching, we are comparing the surface contours of those tool marks to each other. Pattern matching is the worldwide accepted method for fireman tool mark identification. So we're in line with other laboratories.
How unique is the pattern?
In forensic laboratories with fireman tool mark
Can you?
identification.
Visual aids
to
right about
conduct
now would be
those
really
comparisons
helpful.
using that pattern matching method.
And how many marks make up a pattern? That sled.
There's not a policy.
I've been
course
waiting
not.
forever to say
for
this.
counting
I
those
just saw
lines
the
as we
sheriff in
rely
the
on pattern
audience.
matching method, which
The
is
sheriff is
accepted,
near.
throughout
Let's
our
see who
field.
gets that.
So you
for
determine
the super
whether
chat.
it's a pattern, or is there a standard that you go to measure to say, oh, there's this, this, and this, so it meets the definition of a pattern?
Based on all my training experience, looking at those thousands of comparisons, looking at items in which I know match, looking at the agreement that's seen there between those two items, looking at items together that I know are known non-matches, looking at any agreement that may be there.
We need a
of course,
firearms
we would expect
expert.
to see some disagreement in evaluating
We need a
those
firearms expert.
characteristics.
Minority
throughout the
basic
course of my
pistol's not
training,
helping
looking
me.
at all of those. I use that to
This sounds like
base
some
my
bullshit.
opinion on.
I wonder if
that,
Detective Seeds is out there.
in regards to those items.
Wonder how much
teachers
Detective
said
Seeds
that
knows
they had
about
matching
firearms. Maybe I'll
mechanisms.
tweet at him.
So do I understand you correctly that there's no standard that you rely upon to determine whether a pattern exists?
I
See,
use
I have his Twitter
the
around here
pattern matching
somewhere.
method based on the extensive comparisons that I've conducted, looking at the literature, participating in those studies, in order to determine that I can evaluate the difference between the different characteristics that are exhibited on the items, as well as the quality control procedures at SLED that help to ensure that we're issuing a quality product in our results.
So you know it when you see it, but does someone review above you to cross-check to say whether he or she agrees with your pattern analysis?
Runkle's in the
That
chat.
exists at SLED.
Yes, sir, absolutely. Every case that we work
I'll
at
send him a
to issue
link.
conclusion is 100% micro-verified. So that means I look at the evidence.
Sounds like some
I
bullshit.
examine it under the comparison microscope, look at all of those characteristics and features, and arrive at my conclusions, whether things I'm able to identify or
right, send him a
I
link.
say are inconclusive or even eliminate. I come up with those conclusions and write those conclusions down. It's at that time that another court-qualified examiner comes behind and reviews the evidence as well.
I sent him a
They
tweet
look
with
at
the
all the
link.
evidence on the microscope, compare those features as I have independently, and arrive at their own conclusions. If he or she agrees with my conclusions, they're able to sign off on those conclusions, and the process of issuing that report is continued. So that's part of our quality control process that each case undergoes. And another component of that is once he or she agrees or disagrees with that conclusion, the report will undergo.
I sent out an
technical
emergency
administrative
message to
review
Runkle and he
as well as
responds.
the case
Nice.
file to ensure that quality product.
Does the reviewer, the he or she who reviews it, your work, know of your conclusions before they review?
No, sir. We have a blind verification process, so they do not know our results.
And who reviewed your work and the analysis in this case, that's Court's Exhibit Number 1?
Is
The reviewer for this case was Chad Smith.
Does his name appear on this report that I'm overlooking?
His name would not appear on the report.
Of course not. That'd be well too helpful.
As I'm the one issuing the report, his name would be included in the case file documenting his agreement with my conclusions.
Okay. And you're saying Mr. Smith would not have available to him your conclusions before he looked at the shell casings here?
That's correct.
Now, can you say, well, let me ask you, have you ever rendered opinion in court that you have here today that just looking at spent shell casings without having a firearm to test that they came from the same firearm?
great.
I believe
We're going to get Detective Seeds on here. We need help.
You more than once?
I'm unable to recall about how many reports I've issued based on those cycling marks. I believe I have issued a report like that in the past, where I was able to look at those cartridge cases, and I don't remember the details of the case where there was a gun involved or not.
So I'm asking, actually testified in a court of law, not just issuing a report. Do you recall ever offering testimony in a court of law that you have here today, that just looking at spent shell casings on tool mechanisms, that you've concluded they were fired from the same weapon?
I've testified in court approximately 25 times regarding my conclusions. In regards just to, if you're discussing mechanism marks, I would have to recall and check a file. I don't know off the top of my head. But I have testified in court approximately 25 times to my conclusions that I've issued in a report in regards to firearm and tool mark identification.
Detective Seeds is here. Thank God.
Can you hear me?
Earlier,
I can hear you fine.
how many times do you think you've ever?
I can hear you fine.
Okay.
All right. So Detective Seeds, we're listening to this South Carolina trial, and this guy doesn't have the firearm, which also makes things interesting. But what's he saying is he has some casings that purport to be from the firearm that was used during the time of the murder, and he has some casings that purport to be from that same firearm at some other time. And he seems to be saying that based on the markings from the extractor.
Yep.
So his premise is merely by cycling the cartridge without firing it, that there would be enough unique tool marks left on the casing to uniquely identify the firearm, even compared to the same firearm that was produced in a mass production way during the same batch. And I'm thinking to myself, there's no way. So am I full of shit, or is he full of shit?
So generally speaking, you want that round to have been fired, because when it extracts, it's not only going to have that unique marking, but it's also going to have the casing has a very unique, almost punch, if you will, from cycling through that firearm. I personally have never heard of just ejecting the shell casing, like loading the magazine, racking it, and the shell casing coming out of that, leaving that type of an imprint to be able to be utilized in a case like this. I've never heard of that. So, but
that seems to be what he's saying, if I'm understanding his testimony correctly. That seemed to be what he was saying. It's like, I load in the magazine and I chamber the round, and then I decide not to fire it. So I eject the round. And from this, I can leave enough tool marks. I'm like, there's no way on this earth.
Yeah, that would be new to me. I've never heard of that in any capacity. Like I said, generally speaking, you have that force of the round being fired and compared to just an ejection port. So I would find that very hard to believe, and I would like to see some type of case law that would back that up of that being done, because I don't see that being possible to leave enough of an imprint on that shell casing to use that against someone in a case.
All right, so putting aside the I even saw an episode of Law and Order once where they argued that they could tell from the cartridge being loaded in a revolver, they could find enough markings from it being loaded. I'm like, that's even more bullshit, because in a revolver you're just putting in an empty hole and out of an empty hole, as opposed to it being extracted, which at least has some sort of markings. But in an episode of Law and Order once, I saw, just by loading in a revolver that leaves enough markings, which was even more bullshit. But putting aside that crap, if I actually fire the round, so I've now have a fired round.
Yeah.
So obviously that now has a firing pin that's hit the primer. We'll assume we'll assume a center fired, center fired round for the purposes of this exercise. We have that. So what makes that unique enough from one firearm to another to be able to identify, this came from this gun versus that gun?
Yeah, so generally speaking, each firearm, even if it's made by the same manufacturer, so like Glock, for example, if they still have a unique imprint that it obviously can't be seen by the human eye, but you can look at that in a detailed manner in a forensics laboratory to see that consistency and the matching of the round that has been extracted, and then compare that to the actual firearm. So, for example, if I fire a round from my Glock 19, they recover the shell casing as well as the firearm. You can tie that to that based off the markings from the shell casing. Each gun, even if it's compared to another firearm by that manufacturer, it still has its own unique print. It's almost like a fingerprint. We all have different fingerprints, and a gun and a round being extracted is no different.
Is that because the firing pin but when it gets used, gets worn down in some distinct way that's detectable on a micro level?
It's honestly a variety of things, not just the firing pin, but also the ejector on the firearm. When you have that force that's coming out after it's been fired, there is an imprint that is almost stamped. It's like the only way I can compare it is a fingerprint. Because it's unique in its identification. That way you can distinguish it from one firearm to another. It's basically that gun has a fingerprint of its own, and as soon as that round is fired, it's leaving its fingerprint on that shell casing so that it can be compared again under very intense scrutiny in a lab. There's a lot of science that goes behind being able to lift that fingerprint, if you will.
Yeah. I guess I sort of understand this concept when it comes down to the actual bullet passing down the bore. Because
and saying it's not unique, but in a way it sort of is unique in that when each firearm is different. So if I have two Glocks that are fired, and I compare those rounds based off the forensic evidence that we have available now, they're going to produce their own unique print, if you will, to that casing.
Is that a function of the firearm's wear over time? Or if I took two Glock 17s that were made in the same lot, would they off the shelf have enough distinguishment to be able to tell the difference?
I honestly don't know the answer to that, because I've never worked in the forensic side of things, but just for my investigation portion of working shootings, they generally, once we get it back from the lab, they have some form of fingerprint, if you will, that is tied into that particular firearm. And if Ian works obviously, primarily gun cases. So if he's speaking about a fired round, it is different than an unfired round. That's why when we're talking about merely, with it just being cycled through, I don't know how you would be able to tell if that uncycled round is tied to one particular firearm. I just don't. I've never heard of that, and I don't think that you would be able to do that. Again,
he's from the South Carolina Enforcement Division. He might be talking out his ass, but this is like some of the stuff he's talking about. And like, I certainly, I guess I understand the concept that you could have consistency versus inconsistency. I guess where my level of incredulity is coming down to is the idea that I can actually like get to the actual firearm. Because like, if you told me like every firearm, even if mass produced, is going to be a little bit different. And so I can say, okay, this is consistent versus inconsistent. Like, I would buy that. But down to like, there's enough unique marks to be able to tell one Glock 17 from another. I mean, again, if it's the bullet going down the bore, I understand, because there's a lot more to work with, in terms of the wear that would occur on that. I'm just thinking to myself, from the extractor and the pin and stuff, I'm like, is there enough there to get down to the same? Would you like the same level of confidence if I gave you a bullet that went down the bore of a gun versus a cartridge that was fired? You know, there's the cartridge itself. It's like, would you really be able to have the same level of confidence in saying that bullet went down that bore versus this cartridge was extracted by this gun? It just strikes me as weird that would be true.
I don't believe that you would be able to say again. If Ian has other information from some of the studies he's done, I gladly defer to him on that. But I don't see how in court you would be able to argue or have any type of expert come on and say that round was cycled through if it wasn't fired. I just don't know how you would be able to say that definitively.
Yeah. Okay. Well, it's
and
like
I'm
we wanted to
I wasn't available to come on if it's Poppy. I'm on my.
No, you're fine. At least we can listen to you instead of this guy who is pissing us off. So, you know, because this guy is like, he's saying some stuff. I'm like, this seems unlikely to me that this is true.
I've never heard of that. It's always been you have to fire that round. And if I'm still driving, so I'm going to try to pop on. They said Ian's going to be able to come on at 4. I'd like to hear what he says as well on that, since his focus is in that department. But based on the cases that I've worked, when you're talking shootings and homicides and things like that, that round has to be fired. I've never heard otherwise.
Yeah, maybe this is one of those things also that it would be nice, because we're on a preliminary hearing. We're at this point, we're just trying to determine whether or not this expert's going to be able to testify at all or to what. So, like, presumably when he testifies at trial, assuming it's allowed, we might get some visual aids. And for my money, I'd love a good visual aid right about now, because this would be really helpful to be able to see some extractor rounds and see the kind of marks that they leave and be like, oh, okay, this makes sense to me now. Because right now I'm like, because it's like, I know you've pushed outside my area of expertise, and I'm like, I don't know, man.
Yeah, so. I mean, like if you would have said that it was the actual round was fired, then yes, I would say absolutely it's possible, based off of what we've seen from ballistic evidence, to be able to match it to a firearm. But if that round was not fired and it was simply ejected from the ejector port, I don't see how you would be able to tie that whatsoever to any particular gun. I mean, it's essentially like going into a store and just picking up a cartridge, unless they've left like a fingerprint from loading it into the magazine. That's one way you might be able to do that. But just to say, hey, it's got markings, I don't see that.
At the moment, we're talking about tool markings. Would you be able to, because a AR fires with more force than a pistol, would you be able to get better markings from a rifle than a pistol?
No, I mean, again, like when you fire a round, no matter what caliber it is, whether it's a 50 cal, 223, 45, whatever it is, it's going to leave that fingerprint, if you will, on there, no matter what type of round it is. It doesn't, the velocity or how far a round can fire has no distinguishable difference of what type of imprint it leaves on a round that I'm aware of.
Okay, and how about, for example, for a shotgun, just by way of comparison, because there's also shotguns involved in this. I would imagine the case of a pump action shotgun that you might have a different effect than a semi-automatic shotgun. So how does that work with shotguns? Or do you know?
I honestly have never worked a case with a shotgun in terms of doing ballistic, getting any type of ballistic cases back from that. So I don't know, but regardless, it's being fired, and at some point it's still being ejected as you open it up to dump out the casings. So I would expect, and Ian might know on the shotguns, but I would expect you're still going to have some form of marking on that round because of the firing pin hitting. Even though those rounds aren't necessarily ejecting, depending on what type of shotgun you're using, you should still have markings on there to be able to tie it to that particular shotgun. But that is a good question that I just don't know definitively the answer on the shotgun, but I'd imagine it's going to be the same.
Okay. Well, fair enough. Well, those are really all the questions I had for the moment because I didn't know very much about matching firearms based on casing. Like I know a little bit more about them with the bullet for the bore, but when you talk about the casing and matching on the casing, even with a firing pin, you're outside my knowledge base. So I figured I have someone who knows something about the issue. So
Yeah,
I appreciate you dropping
that
by.
Whole thing of, yeah, no problem. That whole thing of the gun wasn't fired and all that, I don't see that happening. And regardless of the firearm, like, I mean, it's going to leave a print. So if it's fired, you're good. If it's not, man, I'd be really interested to see how that plays out because I've never heard of that. I don't even know how that would be possible.
Yeah, it's interesting that even with mass-produced firearms that you can get enough of it, enough to match. That's pretty cool. I think that's the end of Detective Seeds. We've lost Detective Seeds. Well, I'll simply say thank you to Detective Seeds for dropping by, and we will return back to our...
was that it was using ballistic imaging software and that there was a lot of criticism as to its findings there, to the point where one of the authors of the report, Dr. I'm sorry if I don't remember his name, but you heard testimony from Agent Greer about that he actually issued a refutation saying, hey, we didn't mean for this report to undermine or challenge the admissibility of firearms and tool marks identification. So that addresses the NIS report. With the PCAST report, there were 6 recommendations that specifically related to tool marks and firearms identification. And you've heard from Agent Greer about how those various recommendations were either
can we go back to listen to the bits we missed in course? I suppose we can.
There's continued studies about
how far back do we have to go back?
The firearm.
Okay. Now, you were asked about the various criticisms by the NAS, and that's the National Academy of Science. Is that correct?
Yes, sir. That's correct.
And the criticisms in your field.
Regarding my conclusions, in regards just to if you're discussing mechanism marks, I would have to recall and check a file.
I'll go back 20 minutes.
Exhibited on the items, as well as the quality control procedures at SLED that help to ensure that we're issuing a quality product in our results.
So you know it when you see it, but does someone review above you to cross-check to say whether he or she agrees with your pattern analysis? Does that exist at SLED?
Yes, sir, absolutely. Every case that we work at SLED to issue a conclusion is 100% micro-verified. So that means I look at the evidence, I examine it under the comparison microscope, look at all of those characteristics and features, and arrive at my conclusions, whether things I'm able to identify or I say are inconclusive or even eliminate. I come up with those conclusions and write those conclusions down. It's at that time that another court-qualified examiner comes behind.
And Elijah Craig says he was just giving examples with unfired cartridges. All the cartridges he examined were spent casings. That may very well be true. Maybe he was just giving the example, but it still goes to his credibility. Like, even if he was saying, like, it's hypothetical, like, hypothetically, if I had unfired ones, I could match them. Like, if that's true, not true, then, you know, the fact that that wasn't what they examined doesn't matter. Or it hurts his credibility, right? It's like, if I had unfired cartridges, I could totes match them. And I'm like, bullshit. But that's okay, because in this case, I had fired ones, so I could match them. See, it doesn't really help with the credibility. So, yeah, either way.
Behind and reviews the evidence as well. They look at all the evidence on the microscope, compare those features, as I have, independently, and arrive at their own conclusions. If he or she agrees with my conclusions, they're able to sign off on those conclusions, and the process of issuing that report is continued. So that's part of our quality control process that each case undergoes. And another component of that is once he or she agrees or disagrees with that conclusion, the report will undergo a technical administrative review as well as the case file to ensure that quality product.
Does the reviewer, the he or she who reviews it, your work, know of your conclusions before they review?
No, sir. We have a blind verification process, so they do not know our results.
And who reviewed your work and the analysis in this case? That's Court's Exhibit Number 1.
The reviewer for this case was Chad Smith.
And does his name appear on this report that I'm overlooking?
His name would not appear on the report, as I'm the one issuing the report. His name would be included in the case file documenting his agreement with my conclusions.
Okay. And you're saying Mr. Smith would not have available to him your conclusions before he looked at the shell casings here?
That's correct.
Now, can you say, well, let me ask you, have you ever rendered an opinion in court that you have here today that just looking at spent shell casings without having a firearm to test that they came from the same firearm?
I believe I have, yes, sir.
You more than once?
I'm unable to
test shell casings without having a firearm to test that they came from the same firearm.
I believe I have, yes, sir.
You more than once?
I'm unable to recall about how many reports I've issued based on those cycling marks. I believe I have issued a report like that in the past, where I was able to look at those cartridge cases, and I don't remember the details of the case, whether there was a gun involved or not.
So I'm asking, actually testified in a court of law, not just issuing a report. Do you recall ever offering testimony in a court of law that you have here today, that just looking at spent shell casings on tool mechanisms, that you've concluded they were fired from the same weapon?
I've testified in court approximately 25 times regarding my conclusions. In regards just to, if you're discussing mechanism marks, I would have to recall and check a file. I don't know off the top of my head. But I have testified in court approximately 25 times to my conclusions that I've issued in a report in regards to firearm and tool mark identification.
And earlier you were talking about reports. How many times do you think you've ever issued a report where you concluded, just based upon your analysis of the spent shell cartridges, that the cartridge...
It wouldn't surprise me if the judge ruled admissible. I'm not sure that I, as a judge, would really have much choice but to make it admissible either, despite my many misgivings of this because of the relevant legal standards. So that the judge said it's admissible, I'm not even necessarily saying I wouldn't say it's admissible. I'm just kind of skeptical. Sometimes the law is a not friendly place, so okay.
Cartridges were loaded and extracted from the same weapon at some previous time.
I don't have that number with me today.
Is this an uncommon conclusion, or is this something you do fairly regularly?
It's not uncommon. Our ultimate goal in firearms is to identify or eliminate. And in this case, I was unable to identify several of those cartridge cases, as I have that inconclusive result. But in looking at the information, those characteristics on that cartridge, on those cartridge cases, I was able to determine that conclusion and look at those markings and the totality of those areas around the cartridge case to say that those items had been cycled through the firearm at some time. Can
you said you were unable to match the spent shell casings with item 33. Is that correct?
Yes, sir. Item 33 was the rifle.
And that was the rifle provided to you. Were you aware that that rifle was purchased about the same time as another rifle for son Paul, and that was stolen?
I don't know the history of these rifles or how they were recovered or obtained.
Can you? Is there any way for you to tell what year rifle you're referring to in your your report where you say there's matching mechanism marks that were loaded into and extracted from the same firearm. Can you tell that was a 2017 300 or 18, 19, 20?
No, sir, I'm not able to date the firearm.
Okay. Now, you were asked about the various criticisms by the NAS, and that's the National Academy of Science. Is that correct?
Yes, sir, that's correct.
And the criticisms in your field, and they were specifically criticizing the organization to which you adhere to, the Association of Firearm and Tool Mark Examiners, correct?
Our organization issued a response into to those articles. Yes, sir.
Okay, and you said that that SLED continued on, and you know, and did they make any adjustments? Of course, this was before you became the 2009 report was issued before you started at SLED in your capacity. Is that correct?
Yes, sir. I was hired on at SLED in 2014, so I'm unaware of the past of what may have been completed, and I was signed off to conduct firearms examinations in approximately 2017, I believe.
And then there was the report issued by the President's Council of Advisors on Science and Technology in 2016, and you testified about that, correct?
Yes, sir.
And I think you cited to the language that we've included that the firearm analysis field still falls short of scientific criteria for foundational validity. Is that right? That's their criticism?
Yes, sir. I believe that was their criticism.
And one of the specific criticisms was that the AFTE's theory of identification that two tool marks have a common origin when their firearms are in sufficient agreement is circular. That the AFTE declares that an examiner may state that two tool marks have a common origin when their features are in sufficient agreement, and that then defines sufficient agreement as occurring when the examiner considers it a practical impossibility that the tool marks have different origins. Isn't that what you have done in this case?
I have applied the AFTE theory of identification as presented by the PCAS. Doesn't take into effect the full entire theory. They make it seem that circular way when in fact the sufficient agreement threshold that we're looking for as examiners is exhibited, again, when we are looking at those items and those tool marks, so that the amount of agreement is greater than our best known matches that we've ever seen in literature, in our studies, based on peer review, and in other methods, that the agreement is greater than what's seen in the best known non-matches in a consistent agreement with what's seen in known matches. And to help us arrive at that, we're looking at the significance of that. We're looking at the individual peaks and ridges and furrows of those tool marks and those surface contours. We're looking at the relationship of those lines to each other from tool mark to tool mark and how they compare with each other, looking at the width and the depth and the curvature of those lines in order to determine and help us in our process of identification. So there's a little more to the theory than maybe what was presented by the PCAS report.
Another criticism that we've cited is that your field relies on training and experience and uniqueness in lieu of empirical demonstration of accuracy. And isn't that what happened here? You use your training and experience, and there's no objective standard for measuring against whether there's a pattern or not. Is that fair?
We do use our training and experience. That is correct. We rely on those years of looking at those comparisons and conducting those examinations and building up that process to an identification. It's important, I think, to know that firearm and tool market identification is maybe an applied science, something kind of like medicine or engineering, where there's a lot of book work that may be involved, but a lot of the learning may be more hands-on, and it may require training to become proficient, kind of like a residency for a physician. There's nowhere where you can just learn to do this and start tomorrow. There's a lot of training that goes on, hands-on training, and looking at that, much like those other disciplines, like an engineer or a physician who they don't just finish school, they have to go through a process to learn and help hone their skill. And during that time, it helps us to learn and understand the differences in those microscopic comparisons between tool marks.
So would you agree that there's somewhat of an art to your field?
Yes, sir. There could be can be considered that way. As an applied science, there is a little bit of an art to what we do. We use different lighting to look at these marks. We look at these items, these projectiles, these fire cartridge cases at different angles in order to look at them all on a comparison microscope, where we're able to see under high magnification the details within these tool marks, those individual peaks and ridges and furrows, in order to base our identification on. All the while we are there are some objective standards that we're meeting in order to get to that point of an identification. We use measurements of the items, looking at it, counting lands and grooves, to make sure that as we're going up in our identification process, we're kind of like climbing a ladder. Certain characteristics have to agree in order to continue on that process to an identification. So in short, firearms, the identification portion is subjective in nature, but it's based on the applied science and some objectivity that we're able to derive in order to determine those conclusions.
Two other questions for you. One, if you have the opportunity between now and when you testify, will you research to see if you can find any studies where 300 blackout tool marks have been tested to determine whether one 300 blackout produces tool mechanisms?
There is definitely not a study
every
that's
other 300
specific.
blackout in the world. Would you mind doing that?
Yes, sir. I will look into the literature. Again, based on firearm and tool mark identification, there's been hundreds and hundreds of studies throughout the years that demonstrate the reliability of our field and produce those error rates to help us go by that we can fall under. And so, knowing the machining and manufacturing process of some of those components, we can't possibly look at every firearm in the world to compare that to. However, knowing how those guns are machined and taking that information and applying it to the different components and different firearms, those techniques would carry over based on the literature that's been proven. Yes, sir.
I'm asking about 300 blackouts, but if you want to do AR-15s, that's okay.
Yes, sir.
And then, if you don't mind checking your files to see how many times you've issued reports where you just have shell casings and you've concluded that one single weapon was responsible for extracting and ejecting the shell casings.
Yes, sir. I'll see if I can gather that information.
Thank you.
Any redirect?
Nothing from the state, Your Honor.
All right, thank you, sir.
Thank you.
Any argument?
Yes, sir, Your Honor. I believe from Mr. Greer's testimony, Agent Greer's testimony, he's more than established the various factors in the counsel test. I'd like to start with factor 2, and that has been previously applied in similar situations. And again, Agent Greer testified that, of course, firearm and tool mark examination has been done in thousands and thousands and thousands, probably millions of cases all over the world since the turn of the past century, the 19th century. So I think that factor is very well established. The next factor, of course, is the methodology has been published and subject to peer review. You've heard testimony and, of course, the general experience in the courts of how that there have been plenty of studies done and subjected them to peer review. You heard about many studies that have been done in various journals, including the Journal of Forensic Sciences. You've heard about the accreditation process, which also goes into Factor 3, which is quality control procedures. That includes a very rigorous accreditation from ANAB and that sort of thing, which also requires peer review. Then you've heard about the specific quality control procedures at SLED, where they have a specific set of procedures that must be used in order for these tests to be conducted. Finally, you've, of course, heard at SLED about blind review by another examiner who looks at those without knowing the original examiner's conclusions, who then peer reviews those particular results and determines whether or not, or it comes to the same or conclusions, or if not, then obviously there's a problem, and there's not any such problem here. If we look at the particular qualifications of Mr. Greer and just generally firearms and tool marks in general, he talked about the fact that they have to go through competency tests and proficiency tests. And one of the things that he talked about, if you look at whether or not something's repeatable or reproducible, which goes to Factor 1, which of course is the scientific methodology, is he talked about participating in consecutive rifling studies. And so why that's important, Your Honor, is that's the ultimate test of the reliability of this technique.
Let me pull up the language from Gobert, because this is Gobert.
Firearms that have been consecutively manufactured, meaning that there has not been that much time for there to be wear with the manufactured components between those various barrels. And the test to the examiner, the study to the examiner, is can you still distinguish even though those rifle barrels were made one after another? And you heard Agent Greer testify that he participated in those studies and various ones, and he was able to successfully distinguish between the various barrels even though they were consecutively manufactured. That's obviously excellent evidence of the reliability of the methodology and its consistency with recognized laws and procedures. This is an applied science, but you heard Agent Greer, it's a highly recognized one, it's one of long standing, and you heard Agent Greer testify that it's much like medicine and engineering. The fact that it's an applied science does not make it not a science. Agent Greer testified in great detail about much of the criticisms that were in the NAS report and the PCAS report that are cited in the defense motion. And he identified, going through, for example, with the NAS report, one of the things that he pointed out was that there was a lot of criticism about that report. And, Your Honor, in our brief, which I know we filed this morning in response to the defense motion from yesterday, so I don't know if you've had a chance to review it, but we've cited case after case after case that identify the problems and the refutations of that report. But you heard from him the problem with that report was that it was using ballistic imaging software and that there was a lot of criticism as to its findings there, to the point where one of the authors of the report, Dr. I'm sorry if I don't remember his name, but you heard testimony from Agent Greer about that he actually issued a refutation saying, hey, we didn't mean for this report to undermine or challenge the admissibility of firearms and tool marks identification. So that addresses the NAS report. With the PCAS report, there were 6 recommendations that specifically related to tool marks and firearms identification. And you've heard from Agent Greer about how those various recommendations were either already addressed or have been addressed, and how there's continued studies about the accuracy, such as the consecutive barrel test and all the rest of it. And additionally, you heard from Agent Greer that in looking at the criticisms of the PCAS report, which again, if you look at the cases we've cited, has been rejected by the FBI, it's been rejected by the Attorney General of the United States, as well as the Association of Firearms and Tool Examiners, for a number of reasons, but some of the ones you just heard testimony about, including his opinion that those criticisms were valid, were that none of the people involved in that had firearms and tool examination experience, that most of them, or if not all of them, had never even worked in a forensic lab. And of course, ultimately, you heard that they did not take into account the full theory of identification, which is the basis for this particular science. There was certainly some cross-examination about 300 blackout and that sort of thing, but you heard from Agent Greer that 300 blackout is the ammunition is made from common components. And with he mentioned also the AR-15. We are talking about matching whether or not a particular round was cycled through a weapon. Well, the receivers in these weapons, again, there's a standard component process to that. So there still is recognized studies there, and it doesn't change the fact that 300 Blackout is manufactured from commonly made components, much like 223 or other rounds. There's nothing fundamentally different about that. Your Honor, if you look at all those various factors for the council hearing, I believe that they're all established in a great degree. And I think ultimately what we've heard today is the fundamental aspect of weight and non-admissibility. Certainly the defense can cross-examine, they can raise these issues, they can raise criticisms of the science, but it's been more than established we would submit for admissibility into this trial. Thank you, Your Honor.
By the defense.
Yes, Your Honor. The standard for admissibility of expert opinion is the expert has to hold the opinion with the reasonable degree of scientific certainty, whatever the field is. Mr. Greer, Agent Greer, was unable to testify. He would not testify that he held his opinion to a reasonable degree of certainty. And he had to concede that there are no studies to support his opinion that even AR-15 or 300 Blackout, the mechanisms that he relied upon, that they were uniqueness. And so those are, the case law that we rely upon, addresses that, particularly when it gets to the level of certainty of the expert to say it came from this particular weapon. The cases that we cited in our brief reject that. I know there's some contrary law cited by the state, but the basis of his opinion here is simply his experience, as explained by Mr. Waters, of testing rifle bores and handgun bores. And we are not talking about markings on a projectile that went through a rifle or handgun bore. We're talking about ejector marks from when a bullet or shell casing is ejected from a weapon. And that is a bridge too far. Thank you.
I find that the state has met the requirement of admissibility under Rules 702 and 703 of the South Carolina Rules of Evidence, as well as under State v. Council. I find that the evidence proposed will assist the jury in understanding an issue in the case. The witness is well qualified and that the underlying science is reliable. The matters at issue involving this witness will be matters for cross-examination and for the jury to determine its weight. Though the witness did not state that specifically that he holds this opinion to the reasonable degree of scientific certainty, our courts have thoroughly held in numerous cases that there are no magic words that are necessary for an understanding as to the opinion and the level of certainty that a witness has in offering an opinion. So the witness was firm in his opinion based on his years of experience and training, and I find that the findings indicated in State's Court's Exhibit Number 1 is admissible.
Thank you, Your Honor.
Your Honor, can we ask that the state produce the reviewer's report if it exists? And the expert testified that there was a blind review and that it matched his, and we would ask that it would fall under Rule 5 as results of a test.
Says the state.
Your Honor, we've produced the entire case notes and case file. I will double check with the agents, and if there's something else, we're certainly happy to make that available.
Well, the witness said that it would be indicated in the reviewer's report. I think he said that, and so
I think it should be in the case notes that have already been provided, but we will double check, and if there's something that hadn't been provided, I would be surprised if that's the case, but we'll certainly rectify that if that's the case.
all right. Anything else today?
Nothing from the state, Your Honor.
Nothing, Your Honor. We would like to discuss the schedule for in the morning, logistics.
Okay.
That's fine.
Go right ahead.
So do we need to be here before 11?
Well, the jury is due in at 11. Any other matters do you all want to take up before 11?
I think we've resolved everything right now. Now, this is
Jury's not showing up
obviously
till 11?
a big trial
We
and
had
a
to sleep
fluid
in tomorrow.
situation.
Good news for me.
But I would say that we could show up for selection. I'm not aware of anything right now that we need to address, Your Honor.
Sir?
I'm not aware of anything right now that we need to address prior to the jury appearing.
Looks like I get to sleep in a little. The jury doesn't show up till 11. Okay. We'll go over the legal standards. You guys won't like the answer, but I'll give you the answer. He's right. He's right to admit it. You heard me say it's Dauber. We'll go to the South Carolina specific rules and then we'll go to Dauber and you'll see how they track. Need to wait on Runkle? Yeah, well, it's 4 o'clock. I'm not going to wait an hour, but if he shows up in the next reasonable time frame, I'm happy to have him on, of course. I like Runkle. Well, anyways, that's the end of that. All right. So let's go over the relevant rules in South Carolina. And then we'll go over where their rules are coming from. And we'll show you that what these saying makes sense. So let's do some legal analysis. I can be on when you're done work. Oh, if you're at work, I understand. So 6 p.m. Eastern, that's an hour from now. Yeah, I'm not sure we're going to be on that long. In fact, I'm pretty sure we won't be. Let's go to the South Carolina Rules of Evidence. The judge quoted this, if you heard him in his decision, Rule 702 and Rule 703. So let's just go over them. Rule 702. If scientific, technical, or other specialized knowledge will assist the trier of fact to understand the evidence or to determine a fact and issue, a witness qualified as an expert by knowledge, skill, experience, training, or education may testify thereto in the form of opinion or otherwise. So that's pretty broad. It's like, if it will be helpful, then fine. That's all that says. Easy peasy. All right. And let's look up Rule 703. Because he also quoted that. Rule 703. Basis of opinion testimony by experts. The facts or data in the particular case upon which an expert bases an opinion or inference may be those perceived by or made known to the expert at or before the hearing. So you can ask the expert about things they're learning about for the first time when you're questioning them, which makes sense because you might have evidence that you want to bring in that they possibly haven't considered before. So that could happen, and so they're allowed to do that. If of a type reasonably relied upon by experts in a particular field, informing opinions or inferences upon the subject, the facts or data do not need to be admissible. So they're just saying that the underlying facts do not themselves have to be admissible in order for him to form an opinion on it. So you can have an opinion based on facts, even if the facts themselves are not admissible, which makes sense because they could be hypothetical or a lot of other things, right? That they might not necessarily be admissible, or they might relate to cases unrelated to this case, or not this case at least, right? You might ask about facts in a different case that are tangential or related in some sense. Now, the judge also went through some language when he was describing a case that's called counsel, apparently in South Carolina. So South Carolina, is the state-specific decision is called counsel. Some guy versus counsel. His name was apparently counsel, if I understood correctly. But you heard me say, oh, that's just Daubert, which it is. So let's go to Daubert, which is the federal standard. And you'll see a lot of this language the judge was talking about is familiar. So Daubert is the federal standard for rules of evidence in federal law. And here is the rule. Under Rule 702, the federal rules of evidence, and South Carolina is tracking that, right? South Carolina has the same numbering system, which is not always true, but typical, right? So Federal Rule 702, South Carolina Rule 702, right? So under Federal Rule 702, the task of gatekeeping or assuring scientific testimony rests on the trial judge. The trial judge is to ensure the expert testimony is relevant to the task at hand and it relates on a relatable foundation. And then there's some illustrative factors. And some of these factors may sound familiar from what the judge just said and the argument you just heard. Some of these factors will sound familiar. Whether the theory or technique employed by the expert is generally accepted in the scientific community. Whether it's been subject to peer review and publication. Whether it can and has been tested. Whether it has a known error rate. Whether the research was conducted independent of the particular litigation or dependent upon intention to provide testimony, which is more of a civil rule thing, to be quite honest. But it's also just a factor, right? So like, whether it's generally accepted, whether it's subject to peer review, whether it can be tested, whether it has an acceptable error rate, right? These things look familiar. This language should seem familiar to you based on what the judge just said, right? And then the federal rule in Rule 702 talks about a witness who's qualified as an expert may testify if the expert's scientific, technical, or other specialized knowledge will help the trier of fact. Well, geez, that's just what South Carolina just said. The testimony is based on sufficient facts or data. The testimony is a product of reliable principles and method. The expert has reliably applied the principles and methods to the case. Right? That's generally the standard. And so the judge's decision is, again, I'm not telling you you have to like it. I'm telling you it's the law because it's my job. I'm lawgiver. Booyah. The judge is just here basically to make sure it's not complete junk ass science, right? We're here to make sure that it's not complete shit. And as SLED testified, we follow the National Academy of whatever. We follow our National Academy. They follow the ISO standards. We are rated. We are tested. We follow the guidelines. We do peer review and all the stuff. And of course, like any scientific publication or scientific thing, there's some question about some aspects of those things. And there's aspects that disagree, but that's not the standard, right? The standard isn't, is there questioning the science? Because unlike what Fauci said, you are allowed to question the science. It's okay. You are allowed to question the science. It's okay. But still, the question for the trial judge is not whether some experts would disagree or there's some question or some doubt or some paper that says something. That's not the relevant question. The question is, well, will it help the trier of fact? Is it sufficiently reliable? Is it sufficiently established? Is it based on reliable products and methods? And after that, it's for the jury to decide. So the trial judge made absolutely the right decision. And I, as a trial judge, would hope in some sense that I would make the same decision. Now, that being the case, that's my decision as a judge, right? As a role as a judge. If you put me in the role of a juror, I'm still like, there's some bullshit here, which I'm allowed to do because as a juror, I'm the finder of fact, right? As the judge, I'm not the finder of fact. I'm the finder of law. I have to make sure it's legally competent. But whether or not it's true, well, that's what you ask the finder of fact to do. So this goes to show like how I would think about something as a judge versus as a juror. As a judge, I'd be like, admit it. As a juror, I'd be like, I have questions and doubts. I'm not sure I believe this, which is something as a juror I'm allowed to do. I'm allowed to disbelieve anyone's testimony, including an expert in whole or part. So I can say as a juror, this is some bullshit, right? But I can't say that as a judge. So this is the relevant standards that we play with. So I hope that was helpful. And obviously strong, yes, I'd have to hope that more evidence to back this up. And also, for that matter, it would not surprise me in any way if during his testimony we heard more, we saw more, right? This is for a preliminary hearing. This is a little bit quick and dirty in some sense because we're just trying to get past a threshold, right? So it would not surprise me if during trial we had some exhibits and some charts and some photographs and some other things and we flushed it out more. So it may very, very well be the case, and I'm certainly not prejudging it, nor do I have to as the judge. It may very well be the case that during his actual testimony on the stand, there will be more things and we'll be like, oh, okay, that makes sense. Right now, I'm just not there, but that's okay. I don't have to be there because that's not the relevant standard right now. So, yeah. And Camden says that they've lost faith in the legal system. You don't like it when I show you how the sausage is made, do you? I'm sorry. It's just the way it is. Man. Let's see what I can do here. Okay, let me see. I'm going to change this graphic. I'm trying to make thumbnails in the background too. In case you're wondering what I'm doing, I'm trying to make some thumbnails in the background. We don't have to go through the foundation part again. We totally have to go through the foundation part again. We absolutely have to do it. He was very clear. I'm not raising any questions for the purposes of this hearing. We're doing this again. Not for the least of reasons that the jury has to hear it. Because the jury has to understand his credibility. The jury has to understand the basis of his opinion because the juror is the judge of fact. So we're absolutely 100% going to go through all that over again. You will hear everything that you heard again. You may hear more, but you can look forward to hearing it again. So, yeah. Excuse me 1 second. Can't the defense just say he's an expert? If the prosecution lets them. The defense can stipulate to his expertise, but of course, so does the prosecution. They both have to stipulate. So, can the defense stipulate to his expertise? Sure. But as the prosecution, I don't have to agree. I don't stipulate. I don't stipulate to his expertise. I want to prove it. The jury has the right to hear it. Okay. I refuse to stipulate. I want the finding. And I'd absolutely do that as an attorney. It's like, if I want you to hear your expertise, it's like, no, I want you to hear it, all of it. The judge can throw out the jury verdict if it's manifestly against the weight of the evidence or unsupportable at law. But that's, we're nowhere being able to answer any of those kinds of questions, of course, right now. I'm just trying to generate some nice thumbnails for tomorrow's stream. I'm doing the lighted house at Hilton Head for the stream. So I will try to answer your questions and create thumbnails at the same time. I can do both these things. I can't do both these things. But I'm going to try. His testimony will be anemic, maybe. And of course, regardless of what this expert does or does not present, he is one witness among many witnesses. So he is part of the evidentiary package. So the degree to which he's believable or not, even if we wind up discounting him completely, of course, doesn't make the state's case unwinnable or not. So we're nowhere close to being able to assess innocence or guilt. On the evidence we have, I have a lot of questions. I'm like, really? You can get to a precise enough match? As I was saying to Detective Seeds, I'm incredulous. It's like, that's really something you can do? I don't think you can. So I need more as a juror. I need more to be convinced. And him saying, I'm the expert, trust me, well, thanks to Fauci, if no other reason, I'm a little less likely to do that than I might have been at some other time. So I'm going to need a little bit more than, oh, I'm the expert, trust the science. I'm like, I don't know. But we'll see. All right, so let's see. We need to create a new version of this thumbnail, and we need a new version of this thumbnail. So this comes down. Great. This will be the 25th. This will be day 3. We've got in the morning, which is now 11 a.m. Thank God. 25th, day 3. Thank God. All right, change the image. Got some nice lighthouse action for tomorrow. Good luck as expert with what's been presented. Yeah, I know. I agree with that. Thoughts on Nate versus Boozy? Nate is going full T. I saw some of his stream earlier. It was pretty hilarious. I enjoyed it. It has to be said. I did enjoy the stream earlier when I was during my lunch break. I don't really have any thoughts on the case at hand. I think he can get past a motion to dismiss. based on what he has. And that's really all I want to intelligently say about that right now. But I think he can get past a motion to dismiss. And I think Chris Boozy appears to be like dodging service and stuff like that. So he might very well wind up with some sort of default, which would also be hilarious. Yeah, we got the lighthouse at Hilton Head. That's a nice look. That's a nice looking thumbnail. Get some nice little boat action in there. Yeah. Boats. Cool. Then we get discovery. Yeah, absolutely. They matched a fired casing given gun. I understood that. Yeah. 7:38 p.m. Yeah. Apparently that's the time to tweet. Apparently 7:38 is the time to tweet. All tweets will now be at 7:38. I have learned that from Chris Boozy. That is the time to tweet. Who knew? I mean, he is the bot sentinel. I'd like to point out also that bot sentinel has the phrase bot sentinel has two very different meanings depending on how you parse it, right? How do you understand the term bot sentinel? What's he a sentinel of? He's a sentinel of bots, but is he against them or for them, right? Because if you understand bot sentinel as the protector of bots, he's a sentinel for bots. He's the bot sentinel. Then Christopher Boozy's doing a fantastic job. See, he didn't lie to you. You just misunderstood this entire time. He's the bot sentinel. He's defender of the bots, man. It's great. So I noted that, which entertained me. But I'm easily amused. You can't be awake at 7:28? I was awake at 7:28 because I was getting ready to stream. Because I want to be ready for you guys. And I have to put the stream up before I can't close the stream before I create the stream for tomorrow. So I have to be able to redirect you. So if you guys ask questions for another 40 minutes, I'll stay on for Runkle. So can you be engaging for 40 minutes is now your challenge. Ooh, Anna Free's murder trial just had the state rest. I don't really know much about it, to be honest. I know they're retrying it because the wife's letter, which accused the husband, which was admitted in the first trial, which seems odd on its surface to me on first blush.
Tool marks are unique because the tooling wears, so number 2 will be the same.
Yeah, maybe. I guess. I just was a little bit. I had a little bit doubt that somehow you could tell with the extractors and the firing pin that you'd get down to a unique enough wear pattern. But maybe on a microscopic level, I just need more evidence. I need more to be convinced of that proposition. It might be true. I just need more to be convinced of that proposition. And it's like that you can reliably tell, that this came from one firearm versus another. Just seems so. Again, it's like that you could tell it's consistent with it versus not consistent with it, I believe. But that you could get down to enough certainty to say, oh, it must have come from this particular firearm. That's where I'm like having a bit of a doubt fest. Are members of clergy generally excluded from duty? No. Am I going to buy the Harry Potter game? I wasn't really planning on it, but I haven't played any other Harry Potter games. Do I like living in Texas over South Carolina? It's close. South Carolina is a great state. I don't know. I have a lot of time in South Carolina, not as much time in Texas. South Carolina is a great state. I could absolutely see myself moving down there. I'm not sure that I can say I like living in Texas over South Carolina. Tennessee's cool. Nashville's cool. Nashville definitely was on my short list of places to move to. What I think of Louis Rossman's grocery stream? I didn't know that you can stream you shopping groceries. Would you guys like to watch me shopping for groceries? Is that a thing? That seems like not a great idea, but maybe I'm looking at it the wrong way. Texas is the best country in the world. It may very well be. It may very well be. Let's see. I want to create a new live stream. People who have only been to the coast of South Carolina think it's great. I've lived in all parts of the state. I lived there for 20 years. I grew up in Columbia, and I've lived in both the mountains and the low country. I've done it all. How do I feel about Cherokee County, North Carolina? Why not South Carolina? No. They said 11. That's 10 my time. 10 a.m. Okay, great. South Carolina is amazing. Property tax is cheap. That's true. Just served on a jury in August. Change from previous was this time only juror number and general area of employment. I saw South Carolina actual employer name. Is that standard? Apparently. I assume the judge is just doing what's standard. Copy the description. Description there. Copy the title. Put the title here. Change the date to the 25th. Change the time to the morning. Thumbnail. Got the thumbnail. Looks badass. January 25th at 10 a.m. Central Time. Looks good. Create stream. No sales tax and no retirement tax in Tennessee. That's true. That's true. There's sales tax there's income tax in South Carolina. This is a fair point. No income tax in Tennessee, no income tax in Florida, no income tax in Nevada, no income tax in Texas. Where did I get my hat? Well, I'll let the bot give you the answer for that. Great, that's done. Now I need to create a redirect for the stream to tomorrow. So you guys will go there as soon as the stream is done. Redirect, create, add, done, save. Fantastic. So that's all done for tomorrow. See how wonderful that was? Kick ass. Follow-up question. How do I feel about being blown out of your socks in the middle of the night by neighboring Cherokee tribe SWAT team? I'd have to say that I'm not a fan. This does not sound good. Tennessee does border South Carolina. So, I could live in Tennessee and be close to South Carolina. So maybe that's the answer. South Carolina does not border Tennessee. Where's my map? You are correct. It does not. Yes, it does. No, it doesn't. Damn it. Okay, never mind. Strike that. It's close to Tennessee. It's close, but not actually bordering. That's right. Okay, fine. Fine. So yeah. You learned that in 9th grade? Okay, my geography is slightly off. Give me a break. Slightly off. Give me a break. Okay, all I need to do is get Asheville to be annexed by Tennessee, and then I'll be correct. So I'll start petitioning for that right away. I just have to redraw the lines, and then I'll be right. Kurt, your dialect is intriguing to me. Your pronunciation of words like wrong and long sound like hard G or even K. And your button has no glottal stop, but a hard D sound for the T. Well, my pronunciation is now being critiqued by the chat. This is hilarious to me. Thank you for saying I'm funny. I try to be funny. Do I think the jury will be seated tomorrow? I mean, it seems that way, especially if they're not having the jury till 11. I guess they're expecting to be done. It's like I think the judges basically said, "Yeah, we're going to be done." I think the judge has indicated by that. He's in the back. Kick ass. Let me invite him on. There he is. There's the man, the myth, the legend, the runkle.
How are you doing?
How are you, sir?
Oh, a little bit annoyed, but I agree with you that it's admissible. I just think that it shouldn't be.
Yeah, I mean, we were talking to Detective Seeds about the whole thing, and I'm like, okay, I'm just having enough trouble. You know, you have two firearms that are apparently manufactured in the same lot, so they're made by the same factory at the same time, with the same components, and they're interchangeable because, of course, they are. And it's like, but we can distinguish one from another, and apparently, on rounds we're just cycling through the firearm, and I'm like, what? That seems unlikely.
I mean, the problem is that a lot of this stuff is not really done to a high degree of scientific knowledge, because the forensic sciences, and I put that in giant scare quotes, have really come about from police officers trying to find ways to convict people. They tend to be very sloppy on things like, blinding and so forth. So when he says, "Oh, we do this as a blind test," it's like, but you do it as a single item test. So it's not actually blind, my dude. It's not. That's not how that works. A proper, like, if you really wanted to do this properly, what you would do is tell the guy who's, your tool mark analyst, you'd say, "Hey, listen, we don't know whether or not the correct one is in here. And you don't know that because this might be a bullshit thing. Sometimes we'll just give you bullshit." But they should also give them, like, here's 20 different cartridges. Like, here's 20 different casings. Find a match in, like, do an analysis of each of these and see if there's a casing. And all 20 of them should be, if we're talking about 300 blackout, then all 20 should be 300 blackouts from different firearms. Now, the reason why they don't do that is it's a pain in the butt. But when you look at what this comes down to, ultimately this comes down to a guy looking in a comparison microscope, and a comparison microscope is just a fancy microscope that lets you look at two things at once.
Yeah.
And basically going, do these look similar? Now, there's all sorts of ways that they try to, pad this out and say, well, we look at, the length of these grooves and so forth, and that can eliminate some real obvious mismatches. But fundamentally, at the bottom line is that it comes down to, do these two things look the same or do they look different? And, that is something that is inherently problematic. What we're talking about here is we're talking about essentially, a lineup. And I don't know, Like, I've got a video looking at the lineup from The Usual Suspects and pointing out that it's a terrible lineup because everybody in it is a suspect, right? But if you have people do a one-person lineup where it's just like, is this the guy? They will rule out obvious mismatches. Like the guy they saw was white and the guy up in the lineup is black. But beyond that, they will agree with really bad, it's not the guy, but because it's just a single lineup and you fed them this one person, they'll agree with anybody who comes close. And then they'll sit there and, so this is really your problem that you've got, is that when you give these experts a visual comparison task, and they know it's a suspect comparison, right? They know that you're trying to compare this because obviously that's what's going on, right? You've just brought this in and they look at it and they're really inclined to say that there's a match, even when they're not. They do better on the testing because they know that the testing is testing. But what we need to do is actually get the the live conditions to be similar to the conditions that they would experience in a testing phase, and say, like, listen, sometimes we're going to give you tests that are just, we know the correct, like that none of these are matches. And if they persist, like if you've got somebody who keeps finding matches when there's no matches, decertify them. And the flip side of that is that you should also be going, hey, here's, a pile of things, so that they actually have the potential to get it wrong. Because if there's only two, like if it's compare this known item to this, test item, then really there is no wrong answer for this guy, right? There is no possibility for them to get it wrong in a way that anyone can detect. Because it'll be like, hey, what's your take on this? Whereas if you give them, 20 different casings, then it's entirely possible they come back and they're like, I found a match. Your sample item and item 6 are a match. It's like, cool. Item 6 is from a known different gun, so you suck at your job. But we need to have the ability to detect, does this guy suck at his job? And that's really where we're sort of sitting, is they don't have the ability to tell when they're wrong. And so this is not really a science. It's kind of a pseudoscience. It's and we get this. I mean, the problem is that forensic science has thrown out so many of these different, sort of sub-disciplines.
Hair matching, bite marks,
fiber matching, bite marks. They keep coming out with these different things and they keep getting shown to be crap. And it's like, how many times are we actually going to...
many times, more times, several times.
Yeah. We got to go through this a lot before somebody's finally going to be like, maybe we should actually apply some scientific rigor to this. And they don't want to do that because it means they get a lot less matches and a lot fewer people qualify to do this. But
yeah, but like, when we're trying to send people to jail, shouldn't we have some
just,
yeah. Wouldn't that be like a good thing to do? It's like, maybe we should only let things in that are like good.
Yeah, it's the idea.
Questionable. And then I'm sitting over here as judge on civil, sitting over here, and I'm like, well, I guess I'm admitting this expert and secretly hating my life a little bit.
And I mean, a lot of these things come down to, it's really difficult to do, right? Tool mark analysis is basically the idea that anytime you apply a tool to something, the tool wears the thing and the thing wears the tool, right? Both of those things affect each other.
Yeah.
And, so you end up with situations of trying to determine, like, are the patterns that are left by the tool on this particular thing, do they match? And you'll often hear the language of they're consistent, which really means, hey, these things aren't excluded. But aren't excluded gets sort of traded up in people's heads to these things are a match. And I'm like, yeah, we can't actually get there in most cases. In a lot of cases, all that means is just not excluded. So I've got a video I'm trying to make on this. I just need a locksmith. and it's going to be a bit of a pain in the butt. It might end up costing me a whole
Lockpicking
pile, but
sounds like your go-to. Maybe you can get him on. That'd be good.
I would love to. I kind of suspect that if I reach out to him, he'll be like, "Yeah, listen, I am too busy, and you can go after yourself." Because he probably, you know what? By all reports, he's a super nice guy. I suspect he wouldn't actually put the last part in, but I suspect he'd be like, "Listen, dude, I get like 1,000 requests for my time every day, so."
Well,
yeah.
I'm just grateful that you have enough time to spare for Uncivil Law. It makes me feel important.
I got about 600 messages going, Uncivil needs you. And I was like, I better get to this. And I'm like, I'm at work. I can't join the stream quite yet, but this is making me angry. So, yeah. I was also kind of annoyed at how you can see how they close ranks against, any sort of criticism. Like they get this criticism and they're like, well, this guy isn't a forensic guy, so this criticism is no use. And it's like, well, that's actually why he's able to criticize this and why this is able to, why he's able to point out that this is kind of trash is that, he's actually somebody familiar with the scientific method. But then even he sort of backs away from it going, well, I didn't mean to get people to use this evidence less. I'm like,
that was pretty funny. Like, it's like you had to sort of footnote your own paper. It's like, I have questions. I didn't mean these questions in any way to attack the field for trials, though. It's like, okay.
Yeah,
but that's
what
that's the
think
science.
Happens?
That's hashtag science, right?
Yeah. What do you think happens when you address the issues with something? Yeah, but this whole people get pressured with, if we don't agree with this, then guilty people are going to go free. It's like, yeah, but we might also set guilty people free on the basis of wrongful convictions. Because
not that that's ever happened before.
Well, I mean, we covered the Morin case we covered on Trials of the Century. And the guy who actually committed the crime that Morin went to jail for, committed several crimes, like several more serious crimes, in the time it took to catch him. And it's like, if they'd done the investigation properly, they might have actually stopped those other offenses. But yeah, it's frustrating. And I see somebody raising, an anti-CSI. I mean, CSI has convinced people that all of these sciences are magic and that they always get you to the right answer. And I mean, there's two sides to that. One, they'll be like, why don't we have, DNA? Because sometimes there just isn't DNA, right? But the other thing you'll get is people going, well, they've got a DNA match. This guy must be guilty. And it's like, that's not necessarily what a DNA match means. So yeah, it's frustrating, but this one, I mean, I didn't catch all of the testimony from today, but it sounds like they're matching a fired cartridge from their home range to a fired cartridge elsewhere.
Yeah, that
so
sounds.
That's a little.
They don't seem to have the gun, but they do seem to have fired cartridges. They think it's from the same gun from two different locations, one from the murder scene and one from somewhere else. Although I was a little bit vague about that because I was too busy doing research on other things to figure out where. But yeah, he did seem to testify at one point that he could match even the unspent cartridges. And I'm like, no. And that made me, of course, immediately question everything else he said, because I'm like, well, this seems impossible, and so your credibility is attacked, and that's not great.
I mean, you might be able to match. I wouldn't have too much issue with him saying, listen, we've matched unfired to unfired. But if he's saying we matched fired to unfired, I'm like, that's a concern here.
Yeah.
But I mean, ultimately the matching is problematic itself, right? We don't know how good any particular match is because we don't have any comparison. And so it might be great or it might be garbage. And at that point, we're just like, we don't actually know if this is a valid comparison.
Yeah.
So it's frustrating, and I'm going to try to do a video. My idea is to use locks to illustrate the problems that come up and the errors in thinking that we get. But I got to get, it's either going to be expensive or else I got to get somebody to help me. So it's going to be a while.
Yeah. So what else is coming up? Anything good? I'm doing the trial. That's what I'm doing for the next foreseeable future, which apparently is going on to at least February 10th. So that's what I've got on my agenda.
I'm covering I mostly try to cover Canadian law.
Mm-hmm.
So I'm not looking at live streaming these trials. I might do something going back over.
You're welcome to join me, of course, at any time if you like.
Oh, absolutely. I just, I work weird hours and so forth. So sometimes I'm not available and so forth, but I might actually go back over this one and just like, hey, let's talk about this guy's testimony. That might make a decent video.
Yeah.
There's a few cases I'm behind on. I also have some sponsored content that I have to cover.
Ooh, exciting.
Not really. I reject, like, I'm sure you get these emails too, where they're like, hey, do you want to, be sponsored by some, like, what do you call it?
The crypto people email me every once in a while.
Yeah, or you've got people who are like, hey, we've got this Flash game. And it's like, well, I actually hope you get hit by a truck. So no, I will not be promoting your product. The ones that actually get my interest are the ones where it's like, hey, I want to review this because I'm kind of curious. Or the ones where I'm just like, this raises an interesting legal question. And this is actually one where it raises an interesting legal question. So I'm going to be discussing the legalities, and the sponsor company will probably be annoyed. But
that sounds promising.
Is what it is. Is what it is.
Well, what at least I've seen from the preliminaries is that both sides' attorneys and the judge all seem competent at the same time. So
I was actually kind of impressed.
It's a miracle.
The bit I saw, I was like, most of these trials we've covered have had some lawyer who I was just like, who is this guy? Like with Rittenhouse, we had Binger and Krause and with, other, Brooks, we had Brooks.
Elaine.
Yeah, Elaine. These guys actually were making decent arguments. Like the cross, I don't think that, I'm pretty sure defense knew he wasn't going to win on the admissibility argument.
Yeah.
But, he's swinging for the fences on that.
He played his baseball. You got to respect that. He got the judge to have a hearing, and he made he made the right arguments. And he even said, well, they never said, he was sufficiently scientifically secure or, but then the judge pointed out, well, no magic words and under the relevant tests. It's like, yeah. But I think this is potential to be a good trial. I don't really have a strong, understanding of the evidentiary record, but it is very circumstantial. The thing that's going to be able to really seal this guy's fate is the degree to which they're able to bring in motive. Because what seems to happen based on my sort of present view of this thing is this guy was an attorney, prominent attorney. He was stealing from his clients. He stole something to the tune of $10 million. Unrelated to that, his son did a DUI boat, and he killed someone doing it. So his son is now being criminally prosecuted and also sued. And as part of that process, they were looking into his books because, he owned the boats and stuff like that. And so it seemed like he was increasingly desperate to hide what was going on. So he hired someone to unalive him, which failed, but he was trying to do it to raise money from the life insurance money, and then ultimately killed his wife and son out of some combination of shame for what his son had did, rage because maybe they were confronting him, honor killing kind of thing, and it was just like sort of the culmination of the whole thing. So that seems to be the thing, and the degree to which they're able to build that story and bring in the evidence to sell that story is going to be the prosecution's case.
I guess his life insurance must have had a policy against if he unalives himself.
Yeah, I'm not sure how that all panned out. I don't think they paid out, but I'm not sure how that all panned out.
it's interesting because, like, in Canada, they can put in a clause that bars you from collecting if you unalive yourself within a certain period, but not generally. So it's like, and if they put one that's too long, it's an invalid clause. So I mean, he might have actually been able to solve his problems by other means. Because if he's trying to hire somebody, it's like, why is your plan so convoluted, dude? It's I don't know. The problem is that when you get people into this kind of level of stress, they stop making sense because your brain stops being able to really process things properly.
Yeah.
So, yeah, it'll be interesting. I mean, motive is part of it, and it helps a lot with a jury. But I want to see what their what their actual forensic evidence is that ties this guy to it. Because
and the and what James from court has been there personally as well. So he was there obviously in Virginia, and he's there now in South Carolina attending this trial. So we've been hearing from him as well on the reports and stuff like that. They've got goddamn food trucks at the courthouse that sell elephant ears. Ian, funnel cakes.
I would have loved to have food trucks at the Depp trial.
They got goddamn funnel cakes though. I mean, like, what is going on here? This is so weird.
I mean, it's funny because, like, the Depp trial, people accused it of being a circus. It sounds like they're really leaning into that for this one.
Oh yeah, no, I think the town has tried to make efforts to accommodate all the incoming tourism and try to accommodate people. I'm thinking about going down there because apparently James says it's actually super easy to get a press pass. So I'm thinking about getting down there. I get myself a tent and a table and take my laptop down there, and I'm going to stream from the courthouse lawn and just like have the thing as the background and just live stream the trial from the lawn. What do you think?
I mean, that's kind of neat. I'd want to go inside just to see the jurors at least a little bit.
Yeah.
But
maybe James and I can take shifts.
That you gonna trust James with your channel?
Sure. It sounds like a reasonable thing to do. And we were talking about tailgating.
He's actually probably pretty safe on that regard.
We'll get some tailgating. We're going to get some cornhole. We'll invite some people to play behind us. It'll be great.
Every time I hear that, I think something other than
I know you do. It's fine.
Nobody plays cornhole up here. It's tailgating a court proceeding is kind of an interesting move.
Yeah.
You don't want to push it too far because if you got too far, they might start issuing orders. But like, I would be entertained.
When they start busting me for open container, we know we have a problem.
Especially if they bust you for open container in the courtroom.
Yeah, that'd be good. Hold my beer.
You're sitting there with a flask and just like, all right. So,
Spiritual Healer, thank you very much for the gift memberships. We always do appreciate people who give gift memberships, and it'll be good. Yeah, so I'm thinking about that, and we're trying to find a some sort of power station or power bank that can power a laptop all day, so that I can stream with my phone tethered and go from there.
Bring a generator. Like just
I don't want to really bring a generator. I don't want to bring anything gas generated. So I'm trying to find something that will be battery powered or solar powered or something like that. I don't want to run a gas unit when I'm down there.
Fair. I mean, solar panels might work. You just probably are going to need a lot of paneling for that.
Yeah.
And so you're running, what is this, Melon?
Yes, Melon is streaming.
And it's able to spot like when somebody buys gift memberships and so forth.
Yeah, it allows pop-ups through Streamlabs, so you get the nice pop-ups on screen. So I can do the acknowledgments. It's nice.
Yeah, I may have to look into that because one thing I really don't like about StreamYard is that it misses member chats.
Yeah,
and it misses what do you call it? Like when somebody buys gift memberships.
Yeah,
and it sucks not being able to call those out properly. So
see, we figured that problem right out. It just pops up on screen and be like, oh, someone bought 10 gift memberships. Like, great. So you get the pop-up.
Nice.
And I even set it up so that it will do text to speech for more than $5 US super chats. I set to $4.95 to deal with the mobile people, but still, so it'll do text to speech and actually read it on screen.
Yeah, I'm not doing that. I just don't trust somebody out there'll drop the hard R N word into it.
I think it does filter for really bad words, and I think that does filter for some spam filtering. So,
or just something that, like, if read out, like, it doesn't have any bad words, but, like, saying, hey, a particular disease doesn't exist, kind of thing. You're like, hammering the stop super chats button like as fast as you can. So somebody out there will screw with it, and that's why I'm super cautious. Also, I mean, I could see somebody with deep pockets just using it to mess with you. Like, you're trying to talk and they're just like, putting up like a string of characters that it's going to read out or something.
I'm not sure if if that happens, I'll just set the dollar limit. And if they keep doing it, well, at some point I'm just going to sit there and let them, spam as many emojis as they want, so
yeah, you're like, I've knocked it up to $50. Just keep going.
Yeah, that's fine. I'll just sit here, let you, and I'm just like, bunny printer go brr. That sounds good to me. Oh no, please stop. Not in the briar patch. Oh no.
Solid reference right there.
There you go.
Yeah, I mean, I don't know. Maybe I'll try it out for my birthday stream. That's coming up.
Yeah, it's a little bit cheaper than Streamlabs, or a little bit cheaper than StreamYard, and I think it actually lets you have up to 12 members. Not that I would, but it lets you have more members. And if you set it up, this is all through Streamlabs. So if you decide to go with the Pro membership, look at the Ultra, because it's like only a $2 difference, and you get like a lot of other things that can help you with streaming stuff. But then you can get the pop-ups and the alerts, and you can customize all the alerts. So you can customize different dollar amounts and different graphics, and you can get like real creative and all that stuff. So it allows for a lot of creativity.
That actually sounds really cool. So I may have to get that going, because, yeah, I mean, StreamYard is great, and I'm a paid person on StreamYard, but if I can sort of improve things, that might make sense. Somebody was asking, when is the birthday stream? It is January 28th, 5 p.m. Mountain Time is when
that's exciting. What are you doing for it?
I'm going to eat some stupid things. I've got somebody sent me the world's hottest corn chips, so I'm going to try those. And Lindsay, who's often in chat, sent me the Hot Ones like season package. So it's got 12 hot sauces of escalating hotness, or 12 or 10. I forget. I'll have to open it up. But I'm gonna go and make a bunch of wings and try them in order of hotness, and basically do the Hot Ones challenge on stream and maybe die.
That sounds fun, actually.
Yeah. Rob has also been sent the Hot Ones package, so hopefully I can persuade him, although he's not feeling the best right now, so he might bow out of it on the basis.
If you guys want to schedule a time, I'm not really particularly hot wings tolerant, so I probably won't make it very deep into the set. So maybe you don't want to hold for me, or you do because you want to see me suffer, and we'll see how long I can power through. But I might join you on this thing. Are you planning? When are you planning on doing this on the 28th?
Yeah. So you might be able to get one ordered soon, but I don't know if they can deliver that fast. So
okay,
that's kind of a possibility there, or not. If not, I mean, we could do another Hot Wings challenge on another day and just be like, hey, we'll give this a try, because I mean, I like spicy things, and I don't mind causing myself pain.
That's good.
Somebody's saying, have a gallon of milk ready. Yes, I am definitely going to go buy fresh milk.
I'll do some half and half. That's the secret there.
Just half and half cream.
Oh yeah.
I know somebody who's like, he'll come out and he'll pound hot wings with me, but he brings his own yogurt and just like has a big mouthful of yogurt after.
I think I'll order some chicken wings tonight in honor of this stream, because now I'm hungry.
I actually found a place that does pretty decent. There's suicide flavor, like level of hotness. It's not quite enough to it's not quite spicy enough for me, but at least it's close, and it's got good flavor. Whereas a lot of places, when they have like the suicide wings, they
Yes.
tend to taste like cleaning product.
Yes.
So, and
And-
Nikki Lewis is asking if I've tried the Maritime Madness. I've got some of them. Some of them are really good. So,
Are you familiar with the Church of the Subgenius?
vaguely, yes.
Legal Vices mentioned it, and we broke out the holy text and we're reading it. People said it should be Mayan breaded. It's it's pretty interesting stuff from the 70s.
I mean, it's intentionally chaotic, right?
It's intentionally chaotic, yeah.
Um,
We were having some fun with that earlier. All right. Well, the stream tomorrow. How's everything else going for you personally? How's work and all that stuff? Do you want to talk about it or not? Or
I'm
do you
just
care?
I'm working too hard. I'm just trying to. I've been doing a little bit more leather work, just trying to, which means getting fewer videos done, but
Mhm.
just trying to stay sane in a chaotic world here. Because yeah, but this one turned out particularly well. The ox blood color.
That looks really sweet. I do like that
So-
a lot.
Yeah, and so I'll probably make more of these because I really like that particular shade. I'm just kind of playing around with dyeing, and I mean, I got a cutting die to make them, so I can just sort of keep reproducing this particular pouch. And
Okay,
so
well, we got a whole variety of pouches.
yeah, I've got a Liefeld of pouches there, but yeah, and yeah, I've got the plague mask that's got to go out. That one's got to get shipped very soon, but yeah, just trying to keep sane as I work too hard because
I saw
life
I
is
saw
chaos.
Hogue tweeted today, so that's nice.
Yeah, I actually talked to him a little bit a couple days ago, and he sounds
How's he sound on the
like
phone?
he sounds like he's doing pretty well. He's got a long recovery
He
road
won't
and
give
so
me his
forth.
cell number. He doesn't love me as much as you.
He called me, so it was less handing out his cell number. I think it's more of a he'll call me, not the other way around, because I mean he's got rehab and all of that stuff too, right?
I mean, just in general, I asked for his number long ago and he wouldn't give it to me. So
Fair enough. Yeah, no, I just it's just sort of he's sounding like he's pretty good. He's got a fair, he's gonna have a lot of work ahead of him. And but he's also got a lot of people who support him. He's
oh, sure, for sure. And that's been really encouraging, seeing so many people come together, and it's been really validating to see the community thrive. And he's got, a nice little bit of money there to help him with his rehab and any changes that he needs to make. So he's in good financial posture, and it makes me feel like if the worst comes to worst, that there's a community out there for me too. So that's encouraging. Although I'm going to try really hard not to need it, because I'm going and working out at the gym and stuff.
I mean, it's terrifying, right? Because as a lawyer, all of your money is coming in through places that won't, kind of don't necessarily have your back, right? YouTube, if you stop making content, they stop sending you checks. As a lawyer, it's like, well, did you bill the hours? Nope. Okay, great. You're done, kind of thing.
Yeah.
Unless you're on salary, and even then, I've heard so many stories of law firms being like, "Oh yeah, you're on salary and you had a medical issue, so you're fired, and sure you can sue us, but enjoy suing us," right? It's
I'd sue them just for the fun of it.
I mean, I would too, but they'll still make you do it. It's an ugly world, and it's nice to see people coming together and providing that support, because he's gonna need some help. He's gonna, he can sit there doing his rehab knowing that his family's not starving without him. So
yeah, people were asking about the mask. You sold that a while ago, didn't you?
yes, it hasn't shipped yet. It is actually still here. So I've got it's been kind of a pain to find a box. That's the reason why it hasn't gone out yet, is I got to find a box, because this thing is kind of either the boxes are huge, in which case shipping is like all the money, or else so I need to find one that's the right size and shape. So yeah, working on that. But and somebody's asking if I've tried the new #1 hot pepper. I haven't yet, but I do like Reapers, so we'll have to give that a go.
Well, you're a much better man than me when it comes to that. I'm not afraid to admit it. I can't do that stuff.
Oh, well, I mean, it's just, preferences. And I got something I got to send your way. I got to box that up and send because that's done. It's ready
Excellent.
to go.
Well, I look forward to receiving it.
Well, you'll have to tell me sort of what you think when you get it. I've also got to, I probably got to go over it with the Maker's Mark stamp just to, sort of, because I don't have a Maker's Mark on it yet, but I probably should.
Yeah.
So.
All right. Well, I guess I'll sign off for now. But we will be on tomorrow at 11 a.m. Eastern, 10 a.m. Central is when the court comes back. Tomorrow is the individualized voir dire. So what we've done so far is we had the 4 panels of approximately 80 people. We figured out who was qualified, and we're down to, what did they say, 122? 121? The judge said the number. It was something like that. So we're down to 122, I'm going to say. And from that 122, we're going to get together a panel of 18 people, from which, of course, 12 people will ultimately decide the case. So there's going to be the individualized voir dire starting and presumably ending tomorrow. I think the judge setting it for 11 was a subtle indication of like, yeah, this is ending tomorrow. So
they're going to pick the best jurors out of a bad situation.
Yeah. The clerk has been hilarious. If you haven't caught any of this trial, the clerk is so funny because it seems like she knows everybody personally. And she's like, oh yeah, I know where that is. I know where that store is. Oh, that's good. I had lunch there and all the rest of it. It's the most like Southern genteel, like friendly thing you ever heard. It is an interesting, you would describe it as casual is how you would describe it. It's like, I'm expecting the mayor to get up and give the official speech, bringing together the fair any moment.
It sounds like it's super chill, which is kind of the opposite of like the Depp trial, which was like super regimented and everything is super serious. So, yeah, I mean, how big is the town?
The entire county is like 35,000 people. The town's like 3. So they sent out 900 jury summons. So they basically subpoenaed the county.
Yeah.
So,
I mean, you're going to have a lot of recognition in the pool that small.
Yeah.
Yeah, guys, if you ever want to commit a crime and you want to get tried by a jury who doesn't know you, do it in a bigger town. Because you got to love small town like jury pools where it's like, all right, everybody's related to everybody.
A little bit, yeah. It's like, who knows these people? Who they list a list. They go through a list of witnesses, which goes on for like a solid 11, 12 minutes reading it. And they're like, okay, who knows any of these people or has anyone related to these people? Please stand up. And I'm like, oh my god, it's just everyone in the fucking church.
It's like if anybody isn't standing,
that's my sister. That's my first cousin. That's my. Oh my god. Okay, great. That's good. That's fine. This is where we're doing.
It's pretty much if anybody is still seated when they ask that question, it's like, you're on the jury. And they're like, don't we get to voir dire? No. Like, that guy's on the jury. He doesn't know anybody. He's just...
Yeah, when the judge asked if anyone's heard about this from any blogs or whatever, apparently one juror didn't stand up, and the judge was like, really? The judge actually was incredulous. It's like, you haven't heard anything about this case? You don't know anything about it? You do know you have to tell the truth, right? So apparently only one person is like, I don't know anything about this case. Never heard about it. Like, okay, all right.
The one, I've seen the one selection has this guy like smaller town, big issue. And they're asking this guy like, really, you don't know anything about this? He's like, I haven't read a newspaper since 1962. They're like, great. Do you watch the news? He's like, nope. Do you like go online? Don't have a computer. Don't have a TV. Don't read the newspaper. It's like, what do you do? He's like, I drink. And it was like, okay. And I'm like, in some ways, this guy's the ideal juror.
It's like, this is what we've all been looking for. One guy who doesn't know anything. And he's salted the earth on top of it, too.
Yeah,
Oh, man.
he's just
All right.
like super unbiased because he just has been living under a rock. So
Apparently. Well, if it works for you, I guess. All right, I'm going to sign off for now. Thanks, Ian, for joining me. Thanks for bringing some firearm knowledge, and also thanks to Detective Seeds, who joined us earlier. I'll be on tomorrow. This will automatically redirect you to there so that you can go ahead and do all those YouTube things. Remember to hit the share button for the twit, so we can tweet it out and make sure that people get aware of the stream. I've been on Civil Law. Till later, my friends. Cheers and goodbye.